Hello, good morning, good afternoon, good evening, wherever you are tuning in. My name is David Wilkins, and I'm the faculty director of the Harvard Law School Center on the Legal Profession. And I'm just absolutely thrilled to welcome you to this virtual conference on crisis lawyering, legal practice in the new normal. Quite frankly, I can't imagine a more important topic to bring us together than this one today, as we all live through not just the global pandemic, but a whole series of other crises caused by climate change or social justice movements or cybersecurity. We have almost 1,000 people from around the world joining us today for this important discussion. And as you will see, a really star-studded panel, several panels of terrific leaders to help guide our discussion. Just a few housekeeping things before we get started. First, this event is being recorded and will be published on the Center on the Legal Profession's YouTube channel so that people who don't have a chance to join us live will be able to watch it, or maybe some of you will actually want to go back and watch different parts again. We are also very interested in incorporating as much audience question and answer as possible. As I say, we have over 1,000 people joining us from around the world, from the fields of law, crisis management, public relations, students, a whole host of people. So please write your questions in the Zoom question and answer function, and our moderators will relay them to the panelists. You can begin writing really immediately and throughout the day, and we will be monitoring them and get to as many as we possibly can. As I say, we are thrilled to be doing this event, and we are doing it because two amazing leaders have written an extremely important book. Ray Brescia and Eric Stern, who I'll introduce in a second, have written a book entitled Crisis Lawyering, Effective Legal Advocacy in Emergency Situations, which has just been published by NYU Press. We're putting a link in the chat. And we urge you to get the book because we can only really scratch the surface of what they have done in this important book here today. I can't imagine two more qualified people to get us started on this discussion. So Ray is the Honorable Harold R. Tyler Chair in Law and Technology and Professor of Law at Albany Law School. And Eric Stern is a professor at the College of Emergency Preparedness, Homeland Security, and Cybersecurity, and also chair of the faculty at the University of Albany. Again, you can see all of their amazing accomplishments have prepared them to bring together a really exciting group of leaders to address this timely topic. We were very fortunate that Ray and Eric also agreed to write the lead article in the current issue of our digital magazine, The Practice. It's the September and October 2021 issue, which really addresses this issue. And their lead is called Beyond the Comfort Zone, the Personal and Professional Challenges of Crisis Lawyering. And it's really a kind of comparative story about crisis communication and about how to train lawyers in crisis skills. Again, we'll return to all those themes today, and we were very fortunate that my friend Jay Johnson, the former Secretary of Homeland Security, also the former General Counsel of the Defense Department, as well as a senior partner at Paul Weiss, graciously agreed to have a conversation with me about how he thought about these issues from both the perspective of government and private practice. Again, we put a link to the practice, which we'd love for you to read and to become subscribers to as we take up issues like this 6 times every year. So let me give you a sense of what we're going to be doing today. We really have an exciting day lined up for us. After this brief welcome, we're going to hear from Ray and Eric in a conversation about what are some of the central themes of the book. We'll then go to a panel at 10:30 of senior leaders who are going to report on their own experiences from the front lines, looking at case studies in crisis lawyering, in everything from disaster relief to keeping a great university up and running during COVID to major human rights crises and more. We'll then take a very brief break because we know everybody is very busy from 10:30 from 11:30 to 11:45. And then we'll have our second panel, which is moderated by my colleague, Scott Westfall, who also wrote a chapter in the book. And it really will focus around how to prepare leaders for the 21st century. And again, we have an amazing collection of panelists who will talk about this from the perspective of legal education or running an important in-house legal department, or from the perspective of an NGO, because we know that these situations are going to become more and more prevalent in the future, and we need to prepare lawyers to work collaboratively with others to solve these pressing problems, or at least to help address these pressing problems. After that panel, we are very lucky to have a conversation that I will have with Brett Hart, who is the president of United Airlines and the former general counsel of United Airlines, about how that great institution is managing what is the most challenging time, I think it's fair to say, in the airline industry's history. And finally, we'll bring both Ray and Eric back to the stage to have kind of some concluding remarks about where do we go from here. So as you can see, a very, very, very exciting day. And I hope you'll join us for as much as you can of this conversation. And again, I urge you to put your questions in the question and answer function, and we will try to get to as many as possible. But for now, let me begin this discussion by welcoming Ray and Eric to the stage. So please unmute yourselves and turn on your camera. And we are very, very lucky that Dana Walters, who's our associate editor of the practice and really a lead writer, is going to moderate a conversation between Eric and Ray about what the key issues that they identify in this important book. So Dana, thank you very much for doing this, and please take it away.
Thank you, David. And thank you, Ray and Eric, for being here, and all of our participants joining us today. I also want to thank Ray and Eric for bringing their scholarship to the center and to the practice. It's been a privilege to showcase this work. So I'm going to start with the most generic, but probably the reason we're all here today. Ray, I'm going to look to you. I'd love you to tell us about this book. Why did you decide to write it? What were some of the key questions that you were trying to put on the table? Take it away.
Thank you, Dana, and thank you to everyone for participating today, panelists, participants, attendees, and a special thank you to the Center on the Legal Profession and the team there. David and Dana and Brian have been just terrific, and it's been a thrill to work with all of them and to bring this event to you. I want to just correct one thing. Eric and I did not write this book, right? We are the editors. We all we did was bring together, we assembled a remarkable group of contributors. I think if folks peruse the table of contents, you'll see just the range of just wonderful advocates, lawyers, all writing in the first person of their experiences as crisis lawyers. And so that begs the question, sort of, how did this come together? And that is the question you asked. I'm sorry, I went off a little bit there. But when Eric and I first connected across our two institutions, we were thinking about the role that a lawyer sometimes finds themselves in, which is dealing with a crisis situation. And so when we started thinking about this 5 years ago of putting this together, we did not know that the pandemic was on its way. We did not know that there were, going to be 1,000-year floods every year and 100-year storms every 6 months. So as the sort of momentum built around the book, it became more and more apparent that this was something that we had to pull together. And if you've ever worked on a project like this, you send out a lot of fishing lines and you hope that you get some nibbles. Well, I think every line we cast came back with a absolute, yes, thrilled to work on something like this, thrilled. People were thrilled to tell their story, and if people are interested in reading some of the stories in the book, I think they're truly extraordinary. From the lawyer at the Department of Justice who wrote was part of the team that wrote the Ferguson report, all the way up to lawyers and judges working on climate change issues, and even lawyering on election day. Which has taken on a sort of force of its own. So the momentum only built over the course of pulling the book together and working with our remarkable contributors, and it was a real thrill to work on it, and then to see the book have gain the attention that it has, and the work of the issue of the practice that highlights it. I think we've tapped into something. And I think that there's excitement about the ideas in the book, and I think that the bottom line is now, no lawyer can say, oh, they're not a crisis lawyer, given what we've been through over the last 18 months. So I'll leave it there, but thank you again to the center and for everyone who's joined us today, and who will join in the future as this takes on a virtual life of its own after we conclude today.
Thank you, Ray. I'm going to turn to you, Eric, and then afterwards I'll open up the floor to both of you. I'm wondering if you could talk about, Ray sort of scanned the chapters and all the stories that you sought to tell in the book, but thinking about the questions that you wanted to ask and answer throughout, what were those key questions that you wanted to pose to the world and hope that some of the chapter authors answered?
Well, so the broader motivation for the book was to try to understand how members of a profession that have always been connected in various ways to crisis and crisis management have contributed to, sometimes obstructed, the management of crises, and to try to, in a more systematic way than I think had ever been attempted before, to try to pull together the good practices and pitfalls that could help to inform other lawyers about how to better cope with these extraordinary situations. So in the introduction to the volume, and we return to those questions again at the end, pose a number of questions about the nature of crisis, about the extent to which traditional forms of legal education, training, professional development prepare lawyers well to deal with crises, about the challenges of working in multi-professional teams and teams of lawyers as well. Scott Westfall often argues, and does so in the chapter too, that lawyers are often trained to work solo or to work in parallel and then put pieces together rather than being working interactively throughout a problem solving or decision making process. And so we were very interested in the group and team dynamics of lawyers, the way that lawyers are or are not integrated into top-level crisis decision-making groups, and not least the communication challenges, the challenge of communicating advice to folks who are often in highly stressful circumstances, and to manage common tensions between legal circumspection and discretion on the one hand, and broader organizational needs to communicate internally and externally about high stakes issues. And so one of those very interesting cross-professional roles that we looked at in the volume, as I did in some previous work I did with FEMA, together with Brad Kaiserman and Tom Balint, who are both here. We were very interested in the relationship between lawyers and external communicators, public affairs folks. So those are just a flavor of some of the questions. When it comes to the issue of the stories that we chose to include, or the practitioner perspectives, as well as academic perspectives that were present in the book, I began my interest in this topic with the focus of trying to make government work better, and particularly the FEMA case. I was approached by Brad Kaiserman, who we'll hear from today, who was then chief counsel at FEMA, had a very specific problem. He needed to try to change the culture of his law shop to better enable these lawyers to support a high stakes crisis management. And so my approach was really make government work better. Ray came to this, and he's interested in that question too, but he came to this also from the perspective of movement lawyering. And that sometimes there's a need to oppose or constrain the government from the inside or from the outside. And that I think that the combination of those two perspectives and our respective networks has really strengthened the volume. And I think during the last administration, there were quite a number of issues, some of which are documented in the book, where it really became clear that there was a very urgent need in some circumstances for lawyers to be a part of addressing hurtful policies that were enacted. So I don't want to get political, and I am very much a moderate in my inclinations and not particularly partisan, but I do think it was important to say that. So I'll stop there for now. Thank you.
Thank you, Eric. I'm going to open up the floor to both of you. Feel free to jump in. I'm going to read a quote from you because I think, we're starting to get a flavor of what crisis lawyering is, but I want to drill down on that definition. So this is a quote from your lead story in the practice, which I encourage everyone to look at. You write, while lawyers are often well prepared to support clients experiencing crises, they tend to be far less well equipped to deal with situations where the ways in which they or their firms or organizations function are directly impacted by that crisis. So I'd love for you both to just extrapolate on that. What do you mean by that? And in that context, how would you distinguish, for instance, crisis lawyering from regular lawyering?
So I'll take the second question first, and if that's okay. Every client that I have ever represented, and I'm sure many of the people who are here today would agree, that when a client turns to their lawyer, they're usually in some kind of crisis. And there's a threat to their liberty. They may face an eviction. It may be a business where their intellectual property is at stake, and it could mean the end of the business if they can't defend it. But for the lawyer handling those situations, that's not necessarily a crisis for them. So they may be empathetic. They may, feel that, it is a crisis for the client, so I'm going to give it the attention it requires, as they should. But they may know exactly what's at stake. They may know the facts on the ground. They may know what the legal issues are. They may have, if it's litigation, stock pleadings that they can utilize very quickly, prepare, even if it's an emergency and they need to go to court to get an ex parte order, they may have those pleadings, and they probably will have those pleadings if it's a type of emergency that arises in their practice in general. So, they've prepared for just this type of crisis. They know what to do. They know when to do it. They know how to do it. So that's not necessarily a crisis for the lawyer, even though it certainly is a crisis for the client. But there are situations that are crises for lawyers, where the situation is novel, right? We talk about we're a profession that deals with precedent. So a novel crisis is the opposite of that, right? It's unprecedented. The facts on the ground and the law are unknowable, perhaps, and unsettled. There are serious threats to both value and safety, and the decisions have to be made on an accelerated fashion, and the lawyer may not be able to contact and communicate with the client to get clear guidance in that situation. So those features of crisis lawyering, or rather I should say those features of lawyering in crisis situations, are what characterize crisis lawyering. And so, when you've got, I worked on a case years ago involving Haitian refugees being held on Guantanamo Bay, Cuba. That was unprecedented, right? Nothing like that had ever happened before. Today, if you happen to be representing, Waystar Royco, and there's a problem with cruises, right? Like, that's a crisis, and the lawyer doesn't know necessarily where to turn, and they can't fall back on sort of path-dependent approaches, and are in uncharted territories. So that's what, we were trying to get at, those situations where the lawyer was facing a novel situation. The facts were murky at best. The law was unknown and unsettled. There were threats to value and safety, and the decisions had to be made on a very accelerated time frame. I don't want to steal any of Munir Ahmed's story or thunder, but his work, he's going to talk later, challenging the first Muslim travel ban that was issued by the Trump administration. The lawyers got a call at 10:30 at night on a Friday, and I think they had a nationwide injunction imposed less than 24 hours later. So that was crisis lawyering.
Thank you, Ray. Eric, I wonder if you could talk a little bit about something that you brought up earlier, which was collaboration, which I know some of the participants will talk about later, Munir Ahmed for one. You brought it up as part of an aspect of crisis management studies, of which you are an expert. How does teamwork and collaboration factor into the idea of crisis lawyering?
That's a great question, Dana. Thank you. So it's front and center. What we are talking about here are issues that are extreme in an important sense. So I think the metaphor of extreme sports, compared to typical afternoon softball, is a good one here. Crises take people out of their comfort zones in many ways, and we actually use that phrase in the title of our the good piece and the practice that y'all helped us with. And one of the things that's important to keep in mind is that the types of issues that we are talking about here have tremendous complexity. They're often ill-structured, and it's rare that they can be managed by a single person or a single profession. COVID is a great example. It is a very challenging medical and public health issue, but it is not just a medical and public health issue. It's also an economic issue and an educational issue, and it requires communicating difficult and sometimes technically complex messages. And all of this is governed by a variety of legal frameworks, nationally, internationally, and in some cases there may be an international dimension, to that, and the work of international organizations like WHO. So that because these challenges are complex, multidisciplinary, multi-professional, the responses to them also need to be informed by collaboration from a variety of professional perspectives. Admiral Thad Allen, who I think is one of the greatest crisis managers our nation has produced, speaking more broadly than about crisis, but this is very germane to crisis, argues that all great outcomes are co-produced. And that is certainly the case in crisis. And one of the very typical friction points and points of failure is when the teams that engage to deal with a crisis don't share information, don't bring their expertise to bear, don't have constructive, creative problem-solving processes, and poor situational awareness, and they miss the opportunity to intervene in an escalating course of events and move things in a better, healthier, safer, more peaceful, in some cases, direction. Lawyers have a big part in this, and yet the history of crisis management suggests that the role of the lawyer in crisis is not always played well. Sometimes it's not played at all, and then there ends up being a lot of legal work afterwards to clean up the messes that have been created. So I guess that's not all bad from the lawyerly perspective, but from a public good perspective, it's very much suboptimal.
Thank you, Eric, and thank you, Ray. We are unfortunately out of time. I had so many more questions I want to ask you, but this is just impetus for everyone to go check out their story and their book, and we have more stories later. So I'm going to invite David back into the room, and we will turn off our cameras and mute ourselves and get on with the show. Thank you.
Thank you, Dana. Thanks, Ray.
Thank you, Dana. That was a terrific conversation. And of course, there are so many more questions because we're really just at the beginning. And the good news is that both Ray and Eric will be coming back periodically to kind of give us their thoughts. But for now, I want to turn to a really amazing panel of leaders to talk about their own experiences with crisis lawyering and with crises in general, and particularly to pick up on some of the themes that both Eric and Ray raised about dealing in uncertainty and rapidly moving events, and most of all, the need for cross-disciplinary collaboration to solve what are inherently cross-disciplinary problems. I'm going to introduce our amazing panelists one by one, and as I introduce them, I invite them to please turn on their cameras, and then we'll get started. But just to remind you, please do put your questions in the Q&A. We actually got some terrific questions, which we'll try to get to in the course of this and the next panel already for Ray and Eric in their great discussion with Dana. So let me start with Tom Ballance. Tom is currently the Director of Emergency Management at the U.S. Department of Interior, where undoubtedly he's dealing with these issues every day. But this isn't Tom's first rodeo. Before that, he was at FEMA as an Associate Chief Counsel for Resilience and served as a Deputy Assistant Administrator for Grants and Senior Counselor to the Secretary of Homeland Security. And before that, he was the Deputy Attorney General for Homeland Security and Emergency Management for the state of New Jersey. And in these various positions, he's dealt with everything from the COVID crisis currently to the Deepwater Horizon oil spill to the Boston Marathon bombings to the 2017 hurricane season. And if that weren't enough, he's also has been for many years a volunteer firefighter where he serves on the front line of crises. Next, we have Beatrice Lindstrom. I'm so thrilled that Bea is able to join us today. She is a lecturer on law and clinical instructor at the International Human Rights Clinic right here at Harvard Law School. And I've had the chance to have her appear in my class, and I know just what a spectacular thinker and speaker she is. Her work focuses on access to remedies for human rights violations and accountability, with a particular emphasis in Haiti. And as Ray already just said, Haiti has been such a country which has faced so many crises and so many tragic situations. And she's going to talk about one in particular that followed not the most recent earthquake, but the earthquake in 2010 that devastated the country. And what devastated it even more was an outbreak of cholera that unfortunately turned out to have been caused in part or maybe solely by the United Nations. And she'll talk a little bit about what that raised for her as a human rights lawyer working in Haiti. Next, we are very, very fortunate to have my dear friend, Ralph Martin, join us. Ralph is currently the Senior Vice President and General Counsel of Northeastern University. And at Northeastern, he directs everything from kind of city and community affairs to risk management, to labor relations, to legal affairs and public safety, which, as you can imagine, has been really at a critical juncture in the last 18 months to 2 years. But again, this is not Ralph's first rodeo either, because prior to that, he was not only a senior partner, in fact, the Boston managing partner at a major law firm, Big & McCutcheon. But before that, he was the Suffolk County District Attorney for 10 years, where he dealt with crisis situations pretty much on a daily basis. And last, but certainly not least, I want to welcome to the stage Jacob Silverman. Jake is the CEO and member of the board of Kroll Inc., which many of you know is really one of the world's premier investigations and risk consulting firms, which now really has broadened its remit in recent years to look at all kinds of services around digital products related to valuations, governance, risk, and transparency. Again, a place where he deals with crises pretty much on a daily basis. I hope you can see why I'm so excited to begin this conversation. And I'm going to begin, Ralph, with you. And it's partly personal because, as Ralph knows, my son started Northeastern in the fall of 2020, right in the midst, of course, of the COVID outbreak. But Northeastern, unlike many other schools, managed to not only stay open, but to have students on campus, and did a number of really innovative and significant things to respond to the COVID crisis, to keep the university up and running. And I wonder, Ralph, if you might just kind of begin by telling us a little bit about that process, and in particular, how you, in your role as Senior Vice President and General Counsel, collaborated with university administrators, public health people, all the other people, labor relations, that were required for that amazing feat to have taken place.
Thanks, David, and thanks for having me as a participant today. When I think about where we started in facing up to the challenge of the pandemic, I was researching some of the timeline in reverse, and in February of 2020, we were fortunate. We had a literally a world-renowned expert as a faculty member here, who's known for his research in network theory, particularly as it applies to the spread of disease. And we began to get briefings from him in February, and he told us that their early indicators were far too conservative, and that the disease's spread and mortality within the US would be much more ominous than others were predicting at the time. So we knew we had to take action. And here the term "we" is not just a third person reference. The speakers earlier talked about working within the construct of a team. And so the senior leadership team here at Northeastern was very accustomed to working as a team. And all along, I felt that, my participation as the general counsel for the university, and indeed our legal team, was never one-dimensional. So we already had that muscle developed, but I would say this was certainly the most dire challenge we had ever faced at the university. I can only remember one other time professionally where I faced something as dire, but certainly not as long as the pandemic posed as a challenge. So I think to be an effective lawyer, counselor, and partner within the team setting as a lawyer, particularly in the midst of a crisis, means you have to use multiple skills and sensibilities. And so maybe the first point I would make is, and it sounds pretty mundane, is don't just be a lawyer. Be a strategist, understand nuance, and have a view to how multiple constituents, including regulators and the outside world, will view your actions. You're not just making legal decisions, you're making judgment and long-range and far-reaching decisions that will be scrutinized from many different angles. So you have to incorporate those views into the actions that your team is taking and that you're recommending. There are a couple other points, and maybe these seem mundane too, but sometimes in the face of a crisis, people freeze, institutions freeze. And in this case, we all knew that inaction was not an option. But taking action, particularly when there was a great deal of uncertainty about government guidance, government authorization, as well as the law, taking action required assuming a certain amount of risk. And I would say lawyers in general can be risk averse, but if you're trying to guide an enterprise through this very difficult decision tree environment, if we do this, what's the repercussion? If we do that, what's the repercussion? Where the repercussions themselves are not always clear or foreseeable, you cannot freeze, and you do have to take some degree of risk. I mentioned the information that we received from Professor Vespignani. Here, this may fall into one of the strong suits of lawyers. Data and evidence are your allies. We had a lot of data. We had a lot of evidence that guided our decision-making in the first instance, which was to close down, for the most part, the place-based learning for the university. And it's important to use data and evidence wherever you can. I would say another point is you have to identify your constituencies. It's very easy to fall into tunnel vision because of all of the tensions and the loaded or the freighted nature of your decision making. But how are your constituents going to be affected by your decisions? Lawyers are used to making decisions that relate to a client. But in this case, we had multiple constituencies. We had students and their families, faculty, staff. We had others. We had government officials, neighborhood residents. And all of those were going to be impacted by our decision making. Another thing that I think is fundamental to lawyering in a crisis situation is to identify the things that you can control, because not everything is within your control, but in the first order of decision making, those things that you can control and either make decisions that promote safety, mitigate risk, or prevent further harm are things that, that you can take advantage of. The last thing I'll say is, the last point I'll raise is accountability. We made a lot of decisions where, as I've said, either the legality or prudence were not proven. And, you know, lawyers are accustomed to being accountable to clients and courts, and we often service fiduciaries, but being accountable in a crisis puts added pressure on all of those elements of being an effective lawyer. Your judgment is tested, I think, sometimes on an hourly by hourly basis. Certainly during the pandemic, it seemed that way. And everything we did in a team approach, as a lawyer, you're weighing how far an organization can push boundaries, particularly in a crisis. And when the guidance isn't clear, you can't say, I don't know what a court will do. You can't say the law isn't clear. That's not advice and that isn't judgment. So we sometimes have to be accountable by offering judgment that is grounded in other components. Are we making good decisions for the benefit of the community as opposed to a singular dimension, for instance, cost? You know, how will this be viewed? And in making that decision, are there other precedents or other analogous situations that you can point to, even if clarity on that specific decision isn't clear? And ultimately, as fiduciaries, are we making the best decision on behalf of the enterprise and its mission?
Ralph, thank you so much for that really excellent summary of considerations. And in a way, it leads exactly into what I want to talk to Bia about, because the crisis that, Bia, I'd love you to talk about was one in which not only was there whole complexity about who the constituents were and what the facts on the grounds were and how to understand the ramifications, but you were also dealing in a situation not just of legal uncertainty, but one in which maybe the right course of action was one that would really push hard against existing legal frameworks, and yet maybe that's what you thought was necessary in order to try to address the unfolding humanitarian crisis. And so I wonder if you might say a few words about how you really struggled with and ultimately came to terms with that really difficult Gordian knot.
Sure, thank you, David. So this case study takes us back to Haiti in 2010. We were 9 months after a devastating earthquake that had killed about 200,000 people and displaced a third of Port-au-Prince's population. It had flattened 28 out of the 29 government buildings in the capital, including some of the major courts. And so at the time that cholera broke out, it goes without saying that Haiti was already in a state of crisis. And then in October of 2010, I was a young lawyer. I had just arrived in Haiti a month earlier after graduating from law school in the United States. And we started receiving reports that people were quite literally dropping dead from an unknown disease. In the first week, there were 1,000 cases, 135 deaths linked to this disease. And shortly thereafter, the Haitian government confirmed that this was the first cholera outbreak in Haiti's history. And cholera is a waterborne illness that kills through dehydration. And so it's not an emergency for people like us who have the privilege of being able to access clean water and sanitation. But it was for the majority of Haitians who live in extreme poverty throughout the country. And shortly after cholera broke out, evidence also began emerging that the source of the outbreak was a UN peacekeeping base We found out that peacekeepers had arrived from Nepal, where cholera is endemic, a couple of weeks before the outbreak started. Journalists who went to the base, they uncovered leaking pipes and the dumping of fecal matter into open air pits that overflowed into a nearby village, as well as an adjacent stream. And that stream itself fed into Haiti's largest water source, the Artibonite River. And from there, cholera exploded across the entire country. In the first month, 2,000 people died from cholera, and we knew it was only a matter of time before it would reach the capital, where over 1 million people were still living in displacement camps. But this turned from a humanitarian crisis to an accountability crisis that called on the expertise of lawyers when the UN responded to all of this by denying the evidence and refusing to even investigate the source. And so we had activists come to us, ask us to try to use the law to seek accountability and justice for victims. This was an entirely novel situation. We were human rights lawyers working in Haitian courts in international fora, and we had experience responding to grave human rights abuses, even natural disasters. But suing the UN isn't something that's in most lawyers' repertoires, and it certainly was not in ours. And so against the situation, I want to highlight 3 kind of professional responsibility considerations that I think are also relevant to other contexts of crisis lawyering. And I think you'll see some similarities among these points and the points raised by Ralph. But the first is, who do you take direction from? And so as we talked about, the professional responsibility rules envision us having duties to our clients. But in many crisis situations where you're not working in-house within an organization, you may not yet have clients who are able to give direction as to how to respond. And so in that context, figuring out who the key constituents are is a key preliminary step in the work. And in human rights practice, we emphasize the importance of centering the most affected communities and people in those circumstances and taking a lead from their perspectives as to what needs to be done. But we also want to be mindful of taking direction from other local actors, including local lawyers, activists, existing movements, and be willing to work in support of them rather than centering our own perspectives as to what needs to be done. And in this particular situation, those actors were quite clear that they wanted to seek justice for what was happening in Haiti. Which brings me to the second point, which I think is, how do you act when the law isn't conducive to your client's goals and needs? And so in this context, the UN has immunity pursuant to treaty from, quote, all forms of legal process. It also has an obligation to settle claims by civilians, but there's no mechanism that's ever been established in practice that provides a legal forum where you can go and seek compensation. And so as lawyers, there was no place, no forum for us to be able to essentially wage this battle for justice. And so we knew that doing it anyway and trying to pursue justice in this context would have us go up against the letter of the law in many ways. And yet we also needed to engage in creative problem solving to figure out a way forward. And in doing that, the third point that I want to raise is also the importance of considering the broader impacts of both action and inaction in these circumstances. So on the one hand, we were thinking deeply about the cost of inaction. We were in an environment where I was working for one of Haiti's leading public interest law firms. And there really was nobody else who was ready to take up the cause and bring it to the international stage. At the same time, we also thought deeply about the repercussions on human rights more broadly and what it would mean to sue the United Nations in this context, where as human rights lawyers, we depend on a strong and viable UN in order to promote human rights. And so these factors all played in informing our designing a campaign in a way that we hope would ultimately strengthen accountability in the long run rather than take down the UN. And just very briefly, what we decided to do was to ultimately pursue legal claims against the UN, but to do it in a way that also would engage with some of the various factors at play, including in a way that would attract media attention, allow for public engagement, and set the stage for a public advocacy campaign that over the course of 6 years eventually mounted adequate pressure, where the ultimate outcomes was that we lost in court and didn't manage to secure accountability that way, but simultaneously generated enough public pressure that 6 years down the line, on the eve of the case being finally dismissed, the UN in fact admitted responsibility for the outbreak and promised a $400 million remedial package. We're still fighting for implementation of that. That's a story for another day, but I think that maybe brings me to my last point, which is also the importance of staying power. I think crises often demand a quick response and yet don't lend themselves to quick resolution. And so being willing to engage with these questions over the long run, I think are important for all lawyers who are responding to crisis.
Thank you, Bia. And it's a fascinating story. And for those of you who are really interested in this area, I urge you to follow Bia and her work in this area, which has really been path-breaking. But that last point about staying power is a perfect lead into, Jake, where I'd like to go with you. Because, and actually several of the questions that are already coming in sort of are highlighting this, that, you know, we sort of think of crises when the word comes up, what we think of is something like the COVID crisis, or we think of something like the humanitarian crisis that Bia has talked about. But that's not really the only place or that crises happen, and that organizations face all kinds of different crises really every day. And that's particularly true in the business context where you and Kroll do your work. And so the first part is thinking about what crises means to your clients. And the second part, which has already been teed up beautifully, particularly by Ralph, is that these crises are not legal crises alone. They are really complex, interdisciplinary, cross-disciplinary crises that require all sorts of skills. And Kroll is really one of the leading organizations in the world that attempts to bring together all kinds of professionals, including many lawyers, to the kinds of crises that your clients face. And so I wonder, Jake, if you could talk a little bit about the context in which you see it and how you attempt to bring these various parts together, and what role do you hope lawyers play in this process?
Thank you, David. It's great to be here, and there's a lot to unpack in that question. That is, in fact, what we do. So maybe first, it's helpful to provide at least my perspective on what we even mean when we say the word crisis, and to talk about looking at the topic of crisis through the following sort of core lenses. The first is to put the word crisis in context. You know, the common reflex is that a crisis is generally unexpected, it's disconnected from our regular way of existing. It's unpredictable, it's fast, it's acute. Things can happen in seconds. Now, this is the here and now, kind of the micro view. Think of a wildfire, a hurricane, a terrorist attack, a ransomware attack where we happen to spend a lot of our time, plane crash, a death on a movie set. I have the privilege of having a senior colleague at our firm who was a leader of the immediate response to the Boston Marathon bombing when he was at the Boston Police Department. In the micro moment, those few minutes, the words unexpected, acute, horrifying were critical in terms of decision-making and leadership. But when you move out to the macro, I think it's important that we do that. You can really apply the opposite words to make sense of crises. In fact, they are expected. They're patterned. In many cases, the build-up to a crisis and even the existence of a crisis can be slow-moving. You hear the term, watching a slow-moving car crash. In many cases, and frankly, in my view, some aspects of the COVID crisis were, in fact, very slow-moving. In fact, sometimes crises develop over millennia. Climate change, energy policy, cultural complacency or intolerance, profit motives, evolution of the supply chain, technology advancement and vulnerability. You start to see patterns and archetypes that emerge around all of these types of crises. And I guess the key point that I would say is that data is key to understand the pattern recognition, and the muscle memory that is often so critical in those micro moments. Crises are not unique events when looked at through these lenses. There are certainties. One thing I'm certain about is that we live in a VUCA world, and for those unfamiliar with the term, VUCA stands for volatility, uncertainty, complexity, and ambiguity. These are words that a number of my co-panelists have already used. And VUCA is a certainty. So my first sort of comment is think about crisis in context. And sometimes it's really important to come out to that macro view. There are patterns. The second point is that each crisis has a life cycle. The life cycle will vary depending on the nature of the crisis, but they often have similarities. They often have precursors. They often have the scramble after the event. There's the diagnosis and the investigation, which is where we do a lot of our work. There's the remediation. In many cases, there's the retribution. And of course, there's the ongoing learning and the prevention. Understanding if the crisis has which of these elements and where you are in this life cycle is really, really critical. A lot of the work that we do has to do with assessing where we are in the life cycle of an event. A crisis is an event, but there are definitely precursors and postcursors, if that's a word, and understanding where we are is really key. We were called in by a lawyer, and I'll talk about the role of lawyers in a moment, in the aftermath of a major cyber breach. And understanding where we were, the event had already happened, but we came in the moment where there was the scramble. The scramble then had to lead out to all of these different tentacles around what do we have to diagnose? What do we have to investigate? Where can we start remediating? And making sure that we were sequencing and understanding where we are in that sequence was really critical so that we didn't get ahead of our skis, but at the same time, we weren't behind the curve. So knowing where you are in the crisis life cycle is key. Finally, and this point has been made by a number of my colleagues on the panel, crisis is an ecosystem. David, this was a term that I used with you when we spoke earlier. There are so many constituents that have to be analyzed. And in our view, we view every one of these in some way, shape, or form as our client. There's the subjects of the crisis itself, counterparties, lawyers, insiders, boards, insurers, communications directors, supply chain participants, accountants, customers, the press. Nothing happens in a vacuum. If there's a fire, it's not just about calling the fire department. Knowing who the actors are in the ecosystem, what roles and responsibilities are, where those roles are okay to stretch. I think someone said that lawyers can't just be lawyers, and I believe that's true, but we have to understand what the limits of expertise are, who you can trust, what agendas exist. And one thing I will say is there are always agendas. They might be good agendas, but agendas exist. Knowing these attributes can really make all the difference. So think about context, life cycle, and the ecosystem. That's really, really key. A few paradigms that members of our team use when we go in, for example, to investigate a cyber breach or a whistleblower complaint, or a theft of intellectual property, or a theft of actual property. These are pretty straightforward paradigms that we tend to use when analyzing the situation. First, gather information and gather the right information. As I said earlier, data is really important, but there is a lot of exogenous data that really does not matter for you to tackle the mission in the here and now. The here and now is really important. So the second point is stay focused. Stay focused on the immediate objective. Mission creep can really take you backwards if you lose that element of focus. The third is do no harm. And a lot of crisis management, I believe, is borrowed from the medical profession. So do no harm. You are coming into a situation that is traumatic, and the most important set of objectives and goals is to make sure that you're not making the crisis worse. I think it was Bea who said there's a choice often of action or inaction, and understanding which of those paths to take really is critical in doing no harm and trying to advance the objective of resolution, if not prosperity. Finally, and this really comes into play when we come into a situation and when lawyers come into a situation, is remember your outsider perspective, okay? there's a subject of a crisis. It might be a company, often is the case in our case. It might be a government, might be a country, might be a society. But when we are called in, we have to remember our outsider perspective and do our best to actually, while understanding other people's agendas, not be compromised by our own agendas. We are not insiders. We have to offer objective advice. So when it comes to how we interact with lawyers, David, just to wrap up my comments here, in my experience, lawyers are often the first call in a moment of crisis from the affected party. I don't know the statistics on this, but I would suggest the vast majority of situations are that lawyers are the first call. The general counsel may be inside initially, and then that GC or some other risk manager is calling a lawyer. And they're calling the lawyer not just because they want legal advice. In fact, that might not even be the reason, but because lawyers have the privilege and the accountability and the responsibility of being that most trusted advisor in a time of crisis. But then very quickly, a lawyer takes on a very different role. And in our world, the lawyers are often serving as the general contractor of managing a crisis. The lawyers are often, in fact, hiring us and hiring many other advisors or triaging the decision-making about who to bring on, often in a moment's notice. So the lawyer is really a key gatekeeper and an extension of the client or the affected party's interests, and is effectively, in our world, serving as the client. It's very common for us to really only interact with the lawyer who is giving us direction or is taking advice from us, and then triaging that back to the rest of the ecosystem that I just talked about. So our relationship with lawyers is often on the receiving end of a call from a lawyer. And what I would suggest to any lawyer who finds himself in a moment of crisis and representing a subject as an advisor, that having that ecosystem of other subcontractors, if you will, and advisors at the ready, knowing who to call quickly, that you trust for their expertise and their outsider perspective is really, really key. So,
Thanks.
David, those are my perspectives.
Thank you, Jake. That's incredibly helpful, as I knew it would be. And again, we didn't practice this, but you've now teed me up exactly for where I want to go with Tom, because I don't think there's anybody in a position where the clients are not just multiple, but everyone, like the people of the United States of America, at least on one brush, where you have to occupy both the insider and the outsider perspective as a senior government official who's both representing the interests of the people of the United States, but also overseeing things that are deeply important to individuals, communities, businesses, et cetera. And where everyone expects you to be the general contractor role, but where your authority to do so is oftentimes constrained. And so, Tom, I think you heard Eric say that he started this project by trying to think how to help government do better. You're now in charge of trying to help government do better, and you've seen it both from a senior principal role, your current role, but also as a leading lawyer in government as well. And so I wonder, you've now listened to these various perspectives, if you could give us your own on thinking about how you think about crisis lawyering or crisis management and the role of lawyers in that process.
Well, thank you. And thank you for mentioning that I'm a government employee, because I wouldn't be a good government employee or attorney if I didn't give the disclaimer up front that none of my views today or anything except my own, they don't represent that of the Department of the Interior or of the United States government. That being said, anybody who knows me knows that most of my opinions are my own, and I don't hold them back very much. My bias is to government and emergency response. All right, as was mentioned, I was a volunteer firefighter. I'm kind of semi-retired from that these days. I worked in private practice for a while, but just before 9/11, I started with the state of New Jersey as an emergency management and then eventually a Homeland Security attorney. Went to FEMA for a while, and now I'm at the Department of the Interior, where I'm a where I'm the director of emergency management. I'm not in a legal role, but I get to deal with our fantastic solicitor's office who I'm trying to introduce the concepts of crisis lawyering to. And I'm also kind of a preacher of conversations between lawyers and clients. Because one of the worst things I find, especially in government, I don't know how it is in the different sectors that the other panelists work in, is the clients also often come and they ask a yes or no question. And that's probably the worst thing you can do to an attorney, because if you ask a yes or no question, you know what you get a yes or no answer. And my experience in government, that answer is more often no than it is yes. And that creates a lot of problems. So at Interior, it's a fantastic practice I have in emergency management. We've got lands throughout the United States. We've got interests everywhere. You name the hazard, we're involved in it in one way, shape, or form. Of course, lately, COVID's been my chief emergency. That's what I have to deal with. We get a month to turn around putting together a system to collect all of the vaccination information of all of our 60,000 employees. And I have to turn to my solicitor's office, and they're fantastic. And I have to say, here's what we need. And I need you to help me work through this, because I don't know what I don't know, right? I'm turning to the attorneys to say, hey, I don't know what it takes to get this up and running, but we have 30 days and it has to be complete and we need to be going. So getting a good response, getting a good conversation going, not saying, hey, can I do X? And then getting a no answer and coming back and say, hey, can I do Y? And getting a no answer. It's a dialogue. It's a conversation. Start with, hey, here's what I want to do. Help me get there. Tell me where I need to change, what I need to do to get there. But it's also been interesting because COVID, I think, has expanded crisis lawyering from just the what I would call the traditional emergency management type attorneys to a whole host of others. I mentioned the employment law attorneys, right? They're key in all of this. In as you're dealing with COVID and as you're dealing with, employees and whether they should be vaccinated, whether they should be wearing masks, whatever it is, there's a lot of stuff that comes into play. But it's also stuff that suddenly you need an answer to. Now, I can't wait 6 weeks for a memo. I need an answer today. I need an answer tomorrow. And speed is something that you often see in crisis lawyering, is always a challenge there. So you see this suddenly spreading out. Contracting lawyers. I need N95 masks. I need 100,000 of them. I need them tomorrow. And I don't have time to wait for a 15-week contracting process. How do I get this done? Right? Talk to the contracting attorneys, find the exceptions, the ways to get that done in government. I find, for me, the simplest role of an attorney is to help the client accomplish the goal or accomplish the outcomes they need to achieve and limit their exposure to, as I put it, going to jail or getting fired, right? It's a client, I don't want to go to jail, I don't want to get fired, but I do want to know what my risk is. And, so that's it. And within that area, I think there's a couple key concepts that I've seen over the years. I think a crisis attorney really needs to have a solid understanding of the law that they're dealing with. And it's not always going to be the same area of law, but you don't need to be the expert. You don't need to be the definitive go-to person on fill in the blank law. You just need to have a good enough understanding that you can make a call on the spot that you feel is going to enable the client to get what they want done. 9/11 with New Jersey, I've been there about 3 months, and suddenly I find myself in the spotlight because Mayor Giuliani gets on the TV and he says, close all the bridges and tunnels, keep everybody out of New York. The captain of state police, who was the incident commander at the time, turns to me and says, can we do that? I had enough knowledge to know that the state of New Jersey emergency power said yes. The governor empowers the state director of emergency management to control traffic throughout the state during an emergency. And the governor was upstairs and said, as soon as you get the order done, I'm declaring that emergency. I had enough information right there that I said, yes, do it. Be done with it, right? Off they went, they did that. I think you need to be able to communicate the legal risk to clients in a way they can understand it. I kind of jokingly used to tell my team of attorneys at FEMA, remember when you're writing for senior executives, and I guess I'm insulting myself as a senior executive now, they're kind of simple, right? They're not into 27-page legal memorandums. You get 3 paragraphs, restate the issue, add in any additional information, give them a short answer, and then just a short explanation. Then look, attorneys have an obligation to make sure that you fully set forth the law, that you've fully given all the options and everything else. Take that 27 pages and fill in the blanks. But they're not reading beyond that first page. Know that. So communicate what you need to communicate in that short form. Same goes for when you're talking to a client. You need to be able to communicate to them in non-legal terms, because the average client isn't going to understand the legal concepts you're putting in front of them. The information they need to have to understand the risk they face in making their decision. There was a situation where kind of crazy grant situation, but Congress put language in a bill that said you can only fund up to 85% of the risk on this particular grant. Crazy language, right? A lot of interpretation behind it. Don't need to get into the details of it. But it came down to one day when there was, if we did 85.5664, whatever the decimal was, a little more than 85.5% of the risk, we could get 2 more jurisdictions funded, where if we didn't do that, an influential congressman's district wasn't going to get funded. The client wanted to take that and say, oh, we're rounding down. There was no conceivable way that, but it's not a legal issue, right? The language is there. It says 85%. Rounding, that's not a legal issue. There's no law that says you can't round in government. But we were able to explain, it wasn't even me, it was one of the attorneys working for me, explain to the client, hey, you're going to get a very violent reaction from Congress. They put this language in there for a reason. They don't want you doing it. Now, I understand that you also have the risk that you're going to make a very influential congressperson very angry because their jurisdiction's not getting funded. Ultimately, the client appealed it up to me, didn't like my attorney's opinion, and I basically backed my attorney and said, yes, that's absolutely right. But it's your call. You can do what you want. You're not going to go to jail. You're not going to get fired. So this is the risk. We've explained it to you. Now, make your decision. Well, they decided to take our advice, didn't do this little rounding thing. When they went to the Hill to explain what was going on, they got asked about it, and they said, well, we could have rounded down, and they said, no, you made the right decision. So, nice vindication there to have somebody else say it. But just be able to communicate that risk, tell them when it's something that they really need to avoid, and then go from there. And you need to also have conversations with clients. This is a yes or no question I asked before. One of the reasons I really got interested in crisis lawyering was I read an article in one of the New Orleans newspapers back in 2008, 2009, that the headline was Failure of Katrina Housing Program, Fault of the Office of General Counsel. And I sat there, and I was in New Jersey at the time, and said, how could the General Counsel's office be responsible for the failure of the entire Katrina Housing Program? And it talked, in general terms in the article, but it referenced a GAO or an IG report. And I went and read that. And I read that report, and then I made some calls to attorneys I knew at FEMA. And literally what happened was somebody in the command center came to the attorney and said, I want to do X. Is that okay? Can we do this? And the attorney looked at him and said, no, you can't do that. And he said, okay. And they turned around and walked away, went back, said, oh, we can't do that. There's nothing we can do. Have a nice day. So that yes or no question created an entire situation in which the perception was that a failed housing program was the fault of a lawyer. If they said, well, I don't think you can do what you're asking for, but what are you trying to accomplish? And had a conversation. Maybe there's a completely different result that happens in the end. So don't take those yes or no questions. Don't answer them as yes or no. Have a conversation. I try to teach my fellow SES at Interior, don't ask yes or no questions to the attorneys, talk to them. If you got to say no, you're not there to say yes, right? That's not the job of an attorney. But if you have to say no, say it in a way that I can understand why you're telling me no. Give me some information that goes with it. Let me understand it. Let me know why so that I can justify it up my chain of command, that I can do things like that. I heard a couple of the panelists already talk about being a partner or being, what they say, don't just be the lawyer, be a trusted advisor. Clients are going to turn to the lawyer. Yeah, absolutely. Be a partner. The more of a partner that you are, the more likely it is you're going to be at the table to start with. And you have the opportunity to be part of the solution rather than be called up. And I'm not sure who said it on the panel already, But do you want to be called in to mop up afterwards, or do you want to be there so that the solution's there and you don't have to do the mop up in the end? And the last piece I think that's important to crisis leadership or crisis lawyering is leadership. And I don't think we do a good job with attorneys of teaching leadership. And it's an interesting science, and there's a whole some of my classmates in a training program I did a couple years ago used to jokingly call it the leadership industrial complex. There's a lot of stuff on leadership out there, but a lot of it's really good. And you as an attorney have the opportunity to be a leader. It's not going to be in your title. It's not going to be in your job description. It's not going to be in what you do. But you have the opportunity to sit there as a partner at the table and help lead the direction of an organization using your legal skills, but knowing some leadership concepts that'll help you move the goal to where you need it to be so that there's a favorable outcome for what your client wants to achieve, but also that helps you manage that risk that you're always going to be concerned about and helps you be a partner at that table. So I think there's a lot of things we can do there. And, it's just an opportunity. I think as a client, I want an attorney that's going to talk to me, that's going to explain to me, is going to engage with me. I think as an attorney, I've always wanted to be that kind of, provide that kind of service to the client. And I think, and I noticed one of the questions in the Q&A earlier was along the lines of, and I'm really butchering it, but it was, how do we teach this? How do we engage this? Is this something we got to teach in law school? Is this something you learn on the job? What is the way of doing that? And I think that's a great question. I think it's something we need to look at.
So, Tom, that's a perfect segue to tell everyone who's on right now to stay tuned to the next panel, because that really is the focus of the next panel, and it's being led by my terrific colleague Scott Westfall, who runs our executive education programs and has also done a lot, even with our law students, around leadership training. So, thank you very much for that. I want to come back, and this is another set of questions in the comments, Ralph, to you, because a lot of what's been said has to do with you really need to look at the wider picture, you need to consult with people, you need to think about all the various interests, and I can only imagine in a university setting where there are students and faculty in the community, where Northeastern is situated, and the board of trustees, and all sorts of alumni. I mean, there's all these constituents, but of course, they all want maybe different things and have different perspectives, and they're not unified. There's no such thing as the student perspective or the faculty perspective, and yet time is often of the essence. So I wonder, how did you go about trying to understand these various points of view? And then how do you balance them to try to make the kinds of recommendations that I think Tom and Jake were talking about?
So I would say the good news is we've used those muscles before, because it is such a dynamic and complex organization, and it's only gotten more so over the past 10 plus years that I've been here. So we have an active student body, we have an active alumni body, we reside in the middle of 4 neighborhoods, and we're neighbors to all of those neighborhoods, and so that just mentions some of the constituencies. So it's an ongoing thing to try and hear and resolve and calibrate. I would say, I was reminded of a very famous quote by one of our lawyers who, every week we have a team meeting and everyone's invited to submit a quote, and he submitted a quote from Mike Tyson, of all people, which is, everyone has a strategy until they're punched in the mouth. And so using the pandemic as that, to fit within that metaphor, there's nothing like a crisis to focus the mind. And at a certain point, while you can't be oblivious to all of the incoming, you've got to be focused on what's what's the touchstone for what we are trying to do here in the middle of this crisis? And the touchstone for us was safety. And so everything became rationalized, absorbed and synthesized, and then decisions made based on safety, because that was the one thing we felt would support and buttress the legitimacy of anything we decided going forward. So maybe the most fundamental thing is, in the midst of a crisis, what is it that you're seeking to achieve? What are the 1, 2, maybe 3 things that you're seeking to achieve, and rationalize everything towards those objectives rather than the noise?
So, Jake, I want to kind of pick up from that and pick up on something you said earlier, and maybe related to something Tom said, which is you're oftentimes brought in by lawyers, right? Because they're the first port of call, so to speak, when a crisis happens. But as Tom said, lawyers are not necessarily trained to respond to crises in a way that understands their full complexity. They could also, just to be a little blunt, be a little territorial, and I think, as others have said, be a lot risk averse. And so I wonder how you navigate that with lawyers. And this is actually both the lawyers that are bringing you in, but also the lawyers on your own team, because I know you have a number of lawyers on your own team, to get them to understand this kind of broader perspective that ultimately, even in a business context, is in that long-term interest of the business. In other words, it's not just to get the immediate answer to solve today's problem, but they have to think about what the long-term implications are for their business, for their relationship with regulators, consumers, employees, all the rest. How do you do that?
There's no straightforward answer to that. In almost every case, facts, circumstances, and personalities will dictate how we and any member of that ecosystem that I talk about will engage with each other. But I would suggest that what Ralph actually just alluded to, finding that in the here and now moment of crisis, finding that distinct objective, or that touchstone, I think it's a great word, that you can have everyone rallying around, I think is key. Otherwise, you end up with mission creep, as I said, and people pursuing multiple agendas. And when people are pursuing multiple agendas, that's when crises become exacerbated, and you actually do the harm, do more harm versus actually solving the problem. So it really comes down to making sure there's a clarity of mission when you are called in by a lawyer, or when we're calling a lawyer in. And if there is a disconnect relating to what that touchstone is, then you need to go into what I would call immediate mediation and resolution mode, and there are numbers of ways to achieve that, either through like here and now facilitation, or ultimately either you have to figure out what your leverage points are. If there's a disagreement with effectively your client or your lawyer, I think Tom was talking about the idea, if you're forced into a corner, into a yes or no situation, you have to assess what leverage do you have to actually change the dialogue to a conversation, to a resolution, or I hate to say this, either displace or resign. And you have to figure out what those pressure points are that you can utilize. Hopefully, you're working with the team that can center around that touchstone. But if not, you have to go into resolution mode.
So, Bia, no one is pressed in some ways into resolution of conflicting interests more than a human rights lawyer. That's one of the things we discussed when you came to my class. And I wonder how you think about the kind of connection between the normal lawyering tools. So your example is you sued the UN, that's a normal lawyering tool. But ultimately what you are interested in was a kind of negotiation, universal settlement, taking up responsibility that made your clients feel valued, but also brought them some immediate benefits that, quite frankly, litigation might take years and years to do. And I wonder how, as a human rights lawyer in these sorts of crises, you try to balance those things.
Yeah, thank you. I mean, I think oftentimes in responding to crises, as we've discussed, the law doesn't lend itself to neat solutions, or the problems that we face don't fall into those boxes. And so in that sense, I think in crisis lawyering, we often have to be jack of all trades. And I think that there is an important balance to be struck between leading, as Tom mentioned, but also leading with humility. And I think understanding where we can bring expertise, but also how we can bring in others, and where other people's expertise can help widen our perspective on issues like this. In the context of cholera, that was critically important, because I think ultimately the thing that was the most valuable was using legal tools, but also understanding the context in which they were playing out, how they were perceived, and very strategically engaging other allies from across professions, but also parts of society, really, to try to bring them on as allies. And I think in that context, we were able to play a leadership role by keeping an eye on all of those moving pieces, but also trying to grapple with how we do that in a manner that can place other people at the fore, and ensure that the conversation also doesn't get dominated by legal considerations. And I think that's one of the words of caution that I would leave everyone with is to make sure that we keep that broader perspective in mind as we lawyer through these situations.
That's just absolutely critical. And Tom, you've already alluded to this. I'm going to bring Ray on now just to give a concluding remark. But Tom is a lead-in into this. Because in some ways, because this project started out thinking about government, and government inherently has to balance three domains: the legal domain, the policy domain, and the political domain. And you are sitting right in the midst of it. And I wonder, as Ray comes back on, how you think about a government lawyer thinking through those three aspects of policy.
That's a tough one, because it's probably part of the hardest part of a government attorney's job is how to deal with, there are other influences there. The political influence is probably one of the biggest ones, but in policy, we just went through an administration change. There were policies that went from one side of the world to the other side of the world in certain areas. Flexibility, and there's a lot to balance there. And I guess it'll go back to leadership training or learning how to deal with conflict, because you may not agree with policy, you may not agree with the politics, you may not agree with what's coming down your way, but you have to react to it. And I think the comment before was, I forget exactly what it was, something or resign. Sometimes it's something you have to face, but you have an opportunity to help educate, shape, learn. And if you become that trusted partner, if you become that person who can walk in and have the conversation, you have the opportunity to help balance off of those points. But it can be very difficult. We live in very contentious times. We live in, people are angry about whatever the policy is. And I don't care which party's in control of the White House. I don't care which party's putting something up. There's somebody that's not happy with it. And as a government employee or as a government attorney, that's a lot to balance. That's a lot to deal with, because, you've got employees on both sides, you've got administrators on both sides, and you have to learn how to balance that. And that's a tough skill. It's not something that comes easily, but it is something that I think any good attorney, particularly a crisis attorney, is going to need to learn, so that you can balance that, so that you can work with the whoever it is to help balance the policy and the politics and everything else that's involved in it.
So Ray, I know you understand how difficult that is and what Tom just talked about, as well as the other remarks. We're right at time on the panel and we really do try to stay on time. But if you have a brief concluding remark before I thank all of our amazing panelists.
Yeah, very quickly, thank you, David, and thank you all the panelists. I really like the metaphor of the ecosystem that Jacob used, and then I heard a theme throughout, which was accountability, and that accountability in the crisis ecosystem is very different than the normal accountability we might hold to the lawyers, between lawyers and clients. I think it sort of can be summed up in what Louis Brandeis referred to in his own role as a lawyer, that he often saw himself as the lawyer for the situation and not necessarily for a particular client or constituent. Now, that may make us feel uncomfortable. We obviously have to have loyalty to our clients, but I think what I was hearing throughout all of this and what you'll see throughout the book is that that accountability in crisis situations is broader, is more complex, is more diverse than in the typical situation. But I'll leave it there. And I think there's a lot more that everyone's going to talk about on these points.
Well, Ray, I can't imagine a better way to close a panel than with Brandeis, particularly with these Brandesian figures that we have had here with us today. I just want to thank Tom and Ralph and Jake and Bia so much for giving us their time and their wisdom. I know that our audience enjoyed it as much as we did participating, and I hope that all of you will come back. We're going to just take a quick 15-minute break. We'll be back right at 11:45 Eastern time. Not sure what time that is for you, to really take up Tom's challenge of how do we teach these skills and what should we be teaching. But for now, please help me give a virtual round of applause for our amazing panelists. Thank you very much. Thank you.
Thank you.
We'll see you at 11:45. Welcome back, or welcome to those of you who are just joining us for this segment of our virtual conference on crisis lawyering. For those of you who were with us before, I hope you will agree we are off to a terrific start with our two principal conveners, Ray and Eric, who brought us together around this important project, talking a little bit about the framework of their important book, and then an amazing panel of senior leaders talking about their own experience with crisis management and crisis lawyering in particular. We're now going to turn our attention to our next panel, and I am just absolutely thrilled to have my colleague and friend, and I have to admit with pride, former student Scott Westfall, who I will ask to turn on his video and his mic, who will moderate the next panel about how we can teach lawyers in various settings about these critical skills. Scott, thank you very much. The floor is yours.
Thank you, David. It's a pleasure to be with everyone here, and humbling to be part of this conversation with just an incredible range of perspectives and experts here with us. So the critical question that we're going to explore is, does traditional legal education and training in law school through common career paths across the arc of lawyers' careers prepare lawyers well for the rigors of lawyering in crisis situations? The world's becoming more complex, and this is a big question for legal education, both at law schools, but within legal organizations as well, because training needs to occur and across the arc of someone's career. As Tom said earlier, leadership development is really critical in a continuing way across lawyers' careers. We have the perfect combination here for our panel. We have a brilliant clinical legal professor from a very important clinic at Yale Law School, a public sector expert in crisis response who has led a major effort to train lawyers in crisis response in the field, and a general counsel at one of the world's most important companies whose daily life is managing crises. With that, I'm going to ask our panelists, Munir Ahmad, Brad Kaiserman, and Lisa Tanzi, to turn their cameras on, and I'm going to introduce you one by one. And then we'll get to some good questions here. So first, Munir Ahmad is the Deputy Dean for Experiential Education and the Saul Goldman Clinical Professor of Law at Yale Law School. He co-teaches in the Worker and Immigration Rights Clinic at Yale, and he and his students represent individuals, groups, organizations in both litigation and non-litigation matters related to immigration, immigration rights, and labor, and all the intersections among them. He's represented immigrants in a range of labor, immigration, and trafficking issues. For 3 years, he represented a prisoner at Guantanamo Bay, and he's written extensively on all these topics, and most recently a chapter in Crisis Lawyering with his colleague, Michael Wishney, called, the chapter is entitled Calling Air Traffic Control, Confronting Crisis as Lawyers and Teachers. It's one of my favorite chapters in the book. I'll tell you why in a second. Our next panelist, Brad Kaiserman, is the Vice President for Disaster Operations and Logistics at the American Red Cross. Since 2015, he's been in that role. He leads disaster readiness activities and oversees all of the American Red Cross's domestic disaster operations, including all U.S. territories and commonwealths. He and his team are responsible for staffing, logistics, operations, situational awareness, the planning, implementing, managing scalable relief operations to meet the direct needs of disaster clients and assist in their recovery. So it's a huge mandate that he has. Prior to the Red Cross, Brad served in the United States Coast Guard in enlisted, commissioned, and civilian positions for 23 years, was a member of the Federal Senior Executive Service as well, holding legal and operational positions at both the Department of Homeland Security and at FEMA, where he served as chief counsel. We'll say more about that in a little bit. And during over 30 years of public service now, he has taken part in a lot of crisis operations, ranging from the Exxon Valdez oil spill, maritime mass migrations from Haiti and Cuba, international drug interdiction, the piracy of the U.S. flagged vessel Maersk, Alabama, great movie about that, and the response to and recovery from Hurricane Sandy. And finally, we have Lisa Tanzi, who is the Corporate Vice President and General Counsel for Customer Experience and Policy at Microsoft. We'll say more about how unusual that title is and why that title exists as Lisa offers her comments in a bit. She leads a team of approximately 360 people in legal, government, and community affairs, as well as digital crimes professionals located all over the world. She's also responsible for legal support for the Microsoft Commercial Sales Organization, having joined Microsoft in 1995. So back to our key question. We have a lot to talk about here. Does traditional legal education and training in law school through common career paths prepare lawyers well for the rigorous of lawyering in crisis situations? We're going to start with you, Munir, to tell us about your experience as a clinical legal professor teaching at Yale Law School's Worker and Immigration Rights Clinic at the height of the Trump administration's immigration orders banning individuals from predominantly Muslim countries. Munir, I have to say, we haven't met in person ever. Your chapter is brilliant. You unpack the typical approach to clinical legal education, and then you offer some really helpful observations about how law school clinics and clinical faculty can adapt their traditional pedagogical approach to be able to include student teams in crisis lawyering situations. In normal times when you're teaching your clinical students, there's very little time for if you do a plan, do, and reflect model is how you describe it in your chapter. That's not always possible in a crisis situation. And, we'd love for you to tell us about your experience running the clinic, during that extraordinary time. What was similar? What was different in your learning and teaching? What are the takeaways? And what leads you to conclude that crisis lawyering is regular lawyering? Thank you, Munir, for being with us.
Thanks, Scott, and thanks to everyone for the opportunity to join this conversation. Maybe what I'll do is I'll start with a very quick description of the work that we did in around the first Muslim ban, and then come back to the questions that you've posed, Scott, about what this, how this either fit with or departed from the conventional approach of law clinics, and start to suggest some lessons for how we might think about legal education in relation to crisis lawyering and the role of legal education preparing crisis lawyers. So the story that I want to tell begins on January 27th of 2017. It was 1 week into the Trump administration. And my colleague and co-author, Mike Wishney, got a phone call a little after 10 o'clock that night from two of our former students, Becca Heller, who runs the International Refugee Assistance Project, and Justin Cox, who at the time was a litigator with the National Immigration Law Center. And there had been talk in the previous days that some form of Muslim ban was coming, but nobody knew exactly when, and no one knew what the contours of it would be. Becca and Justin called because they had clients who were arriving at JFK Airport that Friday night, and who were being told that they were not going to be allowed into the country, and in fact would be placed on planes and sent back, in this case to Iraq, by operation of this ban, which at that moment no one had actually seen. The two individuals involved, the first, his name was Hamid Khalid Darish. He had been an interpreter for the US military and had worked with US military in Iraq for over a decade. And he was coming on a special visa, which was only available to people who had worked closely with the US military as part of the operations in Iraq and Afghanistan, and had been through kind of extensive vetting in order to be able to obtain this visa. We later learned about a second man who also became our client named Haider Samir Abdul Khalik, who similarly was coming on one of these special visas. But they were held up at the airport at JFK. So that phone call at 10 o'clock or so led to an email which my colleague Mike sent out to a group of our students and other colleagues saying, there are people stuck at JFK. Is anyone available to help put together a quick habeas petition? A habeas petition being a way, a filing in court to get someone released from the government's custody. That then led to probably a dozen students and lawyers from the two organizations who initially placed a call to Mike, as well as the ACLU Immigrants' Rights Project, all getting on the phone for a conference call at about 11 o'clock that evening. I'll fast forward to say that we went from 11 o'clock at night to about 5:30 the next morning, identifying claims, researching to the extent that we could, drafting, and actually filing a complaint for a class action, which got filed at about 5:30 the next morning. We spent the rest of that day engaged in more legal filings in order to set up a hearing, as well as in a range of different kinds of advocacy with community-based organizations, the media, a number of others, because people may recall that that Saturday, airports around the country were swarmed with protesters. And so there was an opportunity there for some intersection between what we were doing on the litigation side and the protests that were going on. This all culminated in a hearing in federal court, a kind of extraordinary hearing on a Saturday night in federal court. The courtroom was packed. The courthouse had a very large group of protesters outside, and a federal judge issued the first injunction nationwide that enjoined the Muslim ban less than 24 hours after it went into effect. So that's what, that was the work. It was roughly 24 hours of work, but it built in some ways upon a structure that we had in place in the clinic, which we didn't realize was set up to handle these kinds of crises, but in some ways was. We had built up over the course of our practice certain kinds of competencies. So for example, the idea that we could toss up a habeas petition was something that in the first instance seemed reasonable because our clinic has done dozens and dozens of habeas petitions in other contexts before, and our students knew how to do that. We institutionally knew how to do that. We had relationships that were essential to this work coming to us in the first place. The work came to us through former students. We were able to quickly engage a large number of organizations and lawyers, many of whom we had longstanding relationships with. So there was pre-existing trust and opportunities for collaboration and the ability to move very quickly, which reflected a kind of vision of our work as being embedded in communities rather than as just operating kind of solo. And we had cultivated a kind of culture of experimentation in the clinic. Many clinics traditionally have tended to take on relatively small matters on a fairly predictable schedule to deliver a uniform experience to each student who comes in. So the kind of paradigm example of a case that a clinic historically might take on is one that begins with a client interview, moves on to some research and some briefing, and ends with a student or students standing up in court and making oral argument. This obviously didn't track onto that schedule at all, but in some ways we had long deviated from that model and had invited into our clinic a kind of experimentation and an ability to try on different kinds of cases, to enter them in different stages and different phases, confident that there would be learning to do regardless of where and when we started. But always kind of coming back to, as you said, Scott, this general approach of plan, do, and reflect. And while the planning in the Muslim ban case was compressed, the doing was accelerated, and the reflection was somewhat delayed. In many ways, we hewed to that same model, even as we pushed each of those three poles in different directions.
Yeah, and one of the things I noticed too, many years that you had to vary somewhat the nature of what you're doing as clinical faculty then, in that you had to do more of the work than typically you might. You're typically in the background, the students are in the foreground doing the work, but by watching you and Mike and your other colleagues, operate, and the students, as apprentices, it sounded more like the regular kind of the traditional apprentice model, but there they were. Thoughts and reflections for other clinical faculty members about how they should think about this and that balance between what the students do and what you did?
Yeah, so, there are historically these two hallmarks of clinical legal education. The first is for students to assume the role, to assume professional role and to take on the responsibilities that come with being out in front, rather than being an apprentice or being an intern to a lawyer. And the second is critical reflection. And you're right that in this case and in other emergent situations, there have been, it's really been necessary for us to deviate from that paradigm. And at different stages, we as the experienced lawyers have stepped more into the role that traditionally students would occupy in a clinic. We have not done that lightly, and we are quite committed in our clinic here and really in all the clinics at Yale, as is the case at Harvard, and most schools across the country. We're quite committed to that principle of role assumption, because for students to step into professional role and to feel viscerally what it means to carry responsibility for a client, and to understand that they have ethical duties, ethical obligations that, don't go away at 5 p.m. or don't go away at 11 p.m. when you go to sleep. That's actually quite essential to the pedagogy. That said, we have, through the experience with the Muslim ban litigation and other types of crisis lawyering that we've done, we've also recognized that there is pedagogical value, or there can be pedagogical value to some deviation from that. And we talk about this in terms of modeling. So for our students to see us as experienced lawyers moving into spaces that are also unfamiliar to us invites a kind of humility on our part as teachers. It reminds us of what it's like to, for our student, what we ask our students to do every day in the clinic. For us to do it periodically, I think is quite helpful. It deepens our sense of empathy for what the students are doing. It reminds us how difficult it is, but it also gives the students something to look at and to react to. I found that one of the most satisfying moments actually in my teaching has been when the table is flipped and I'm no longer mooting my students, but my students are mooting me. And we don't do it that often, but when we do, again, it's a different kind of learning experience for the students, and it enhances, I think, our ability as teachers going forward.
And as someone who teaches about leadership and teams and the courses for law students that I teach and in our executive education leadership programs, I think it's marvelous that they're getting that experience of a non-hierarchical team where everybody is contributing, everybody is moving together and solving the problem with people taking on different roles. It's something in my opinion, we don't do enough of in legal education, and we're not preparing people. This is a perfect segue to you, Lisa. As we talked about on a recent call, it'd be great if you could share your perspective about how crisis lawyering permeates throughout corporate practice, especially in the very challenging, uncertain times that we're living in at a very important global company like Microsoft. In your environment and in your role, you noted that things don't get to you unless they're really tough and challenging and probably already a crisis. Almost every day is an opportunity for crisis lawyering. Building upon Munir's contribution here on this idea of modeling. What are some of the techniques you've developed to help prepare your lawyers for this new environment, especially as they become more senior? And also, I'd love for you to tell us some about how the Microsoft legal department generally has been reorganizing in a really incredible way to meet the interdisciplinary challenges that this perpetual state of crisis, seems to bring forward. And thank you so much for being with us, Lisa.
Thanks, Scott. And I'll just start by saying, when I thought about crisis lawyering, I wasn't entirely sure the first place I would go was in-house lawyering. But as I started to sort of just think through the different things we deal with on a regular basis, I was like, yep, we've got our own sets of experiences here too. And so what I thought I'd do before I jumped into some specific examples is just reflect a little bit on the characteristics that I think are pretty consistent across all of the scenarios. And they echo a lot of what people have, written about as well. I mean, it's, an issue of significant impact and importance. It's usually a surprise. There's some kind of uncontrollable event, typically external, but I will also put a footnote on in the corporate environment, it can certainly be internal as well, and I'll spend a bit of time on that. And obviously, then we're trying to make key decisions with a limited amount of time and a limited amount of information. And so when you just think across, what are all the potential external types of events that can cause crisis lawyering? They're vast and they're very different, right? You can go from something like COVID, which has a super broad impact, to something that is very company specific. So when I think about COVID and when that first hit, for us, we were dealing with everything from obviously employee safety issues to, oh my gosh, some countries around the world actually require physical signatures and not digital signatures. And how do we sign contracts and book revenue, to lockdown orders going in effect around the world? And how do we get our employees to data centers? And, what happens if they weren't identified as essential workers, but government officials aren't in their offices? And so how do we engage to make the case? And what do we do when employees are harassed on the streets because they're out in violation of a lockdown order, right? Like, that's one broad span. But then you could go to stuff that might be even sort of more sector specific. And you and I talked about this on the call the other day, where we do see a lot of countries around the world getting faster in their pace of regulation. So it passes more quickly, doesn't have the same kind of engagement with industry. And then even more importantly, timelines for new legislation to go into effect are very short, or they're getting shorter. And for us, when we think about, oh my gosh, well, now how do we get all of our products ready in such a short period of time? That can cause some crisis thinking for us. Then I'll just shift and say, hey, think about either company or even industry scenarios as well on something like cyber attacks or ransomware attacks. Or, you have a dispute with a government and you're in the middle of a dawn raid, which means, officials come in, they start taking papers, computers, start talking to employees. Or there might be other employee safety issues where people are called in for intense questioning, or they get visited at home, or they're wrongfully detained. So very vast set of external issues. But I also did want to pause a little bit on maybe the internal surprises. And because they happen, and you'd think they might be more controllable, but they happen. And I'll just give two here. We create different versions of our products sometimes for different regions based on regulatory requirements. And occasionally you might find yourself waking up to an email that says, oh, we might have shipped the wrong thing into the wrong country. And then, you're scrambling because you have a compliance issue that you have to clean up. Or, you're at the end of a long negotiation and a deal. You've kind of gotten just ready to do the PR announcements. You put that in motion and you go through the internal processes and you find out somebody missed a step and we actually don't have all the right approvals, right? They're not the same type of crises, obviously, as Munir is talking about, but they do generate that same kind of, oh my gosh, I've got to solve for something pretty important in a short period of time. So then when I reflect on kind of what do we do to think about how do we prepare people, how do we better prepare ourselves collectively for any future crises, I sort of look at it by saying, hey, never let a crisis go to waste. And what I mean by that is we have to learn from everyone we actually do, because we'll make some different mistakes, but gosh, I hope I don't make the same mistake twice. And so a super important piece of this for us is actually postmortems. And, that's the crisis is over. We want to give people time before we do postmortems. I think that's super important for a couple reasons. One, a lot of times people have lack of sleep during crises, and you want to get people an ability to just kind of get rested. And also, I think distance helps with perspective. But then we get everybody on the team together. We kind of just, do a couple of hours in a conference room or virtual teams now and just sort of say, hey, what went well? What did we miss? What would we have done differently? A lot of times this comes down to role clarity, process clarity. And we write down our learnings where we like playbooks, because playbooks at least give people a place to start the next time. Sharing out your learnings is important. Also, I would say trainings are important on some different disciplines that maybe lawyers don't typically get in law school, at least not when I was there. PR training is actually super important for us, because PR messaging, how you engage with all of your stakeholders, is usually a critical part of a crisis. They're core members of our team, but we want our lawyers to be sensitive to thinking through PR issues. Also, program management skills, because a lot of times we find our lawyers are kind of the organizers. They're the ones sort of bringing the teams together, helping figure out who needs to be informed, what are the next tasks, how do we bring people together to report out. And then I would go to kind of what you were mentioning there, Scott, about our recent reorg. Sometimes you do make structural changes. And we did make some big structural changes back in July of this year. And the framing for that was, when we look ahead for the technology industry, we think we're going to see a lot more regulation on all fronts in the coming years. And we need to be ready for that. We can't be reactive. And so a core part of our reorg was getting clear on roles and responsibilities for how each entity was going to participate in that. And then thinking through how we pull together our multiple disciplines, both within CELA and outside. Like for us, engineering help is obviously super important. But how do we bring those together so that we really do approach this from a multidisciplinary perspective?
Which is, highly unusual in the legal, world and structure. And so we're following this really closely, hope to write a case about you all someday that we could be teaching about. Picking up on one of the things that you talked about in particular, this idea of the post-mortem. One of the things that, I contributed a chapter in the book and talk about is the fact that we haven't, and it's mentioned before, we haven't trained lawyers how to work in teams. The experts would say that lawyers typically work in a hierarchical, loose working group, where there's someone at the top and things trickle down and stuff is kind of assembled back up, but there's not a team launch meeting. There's not regular reflection about what's going well, what's not, and there's very rarely a post-mortem. How did you decide and get, how have you been able to get lawyers to do that? Because they're always moving to the next thing, right?
Yeah. For us, it's definitely cultural. I mean, it's been around for a while, but if I sort of think back to when we started, because at some point it was new for us, right? And I would say there were probably some places where we felt just things didn't go super well, right? And, Brad, our general counsel at that point, was pushing us to say, look, we need to do something different. We need to have sort of a learning culture. And for us, that's also an important part of the Microsoft culture now, where Satya sort of talks about, growth mindset and saying we're not know-it-alls, we're learn-it-alls, right? So it is this constant notion of learning and reflecting. But I'll also say feedback is an important part of the culture. And this, I will say, is, can sometimes be challenging for lawyers because, we're all trained to debate, right? And to push and pull on issues, and really talking about, the culture of feedback, because then you can kind of get into a post-mortem environment. And it's not about pointing out something that somebody did wrong. We all sort of go, hey, this isn't about any blame or wrong, signing wrong. It's about how do we get better as a team? And I think if you can create the culture where everybody is like this is not a harmful thing, this is a helpful thing to make us all better, that is just super important to have this, I think, work well. Because if people aren't honest going into that postmortem because people are afraid, you don't get the real value out of the postmortem.
Right, and these structures, can be incredibly important to create that learning and open culture, which is really important. I tell all my law students, Munir, that they have to take a clinic before they leave Harvard Law School, because that's the one place where they're actually working in teams. Otherwise, you can go through 3 years of legal education never working in a team, which is something we have to fix, and we're trying. But building upon that theme, one of the most important post-mortem reflection efforts in, I think, U.S. crisis leadership history, something that, Brad, you actually led. You've been thinking about these issues for a very long time. When you were FEMA chief counsel in the aftermath of Hurricane Katrina, you led this effort to improve the performance of FEMA lawyers in crisis situation through a massive post-mortem. One of my favorite quotes that came out of that post-mortem from a FEMA emergency response officer in the field was, look, I don't need my lawyer to keep me out of court. I need my lawyer to keep me out of jail. And the post-mortem that you did and the context in which you and your colleagues addressed what were the gaps in the delivery of legal services in that crisis, and how could FEMA lawyers be trained and developed to do better the next time around. We'd love to hear your thoughts on that, and just more generally, what it means to be a salty lawyer. And I'll let you explain that.
Thank you very much. So it's a fascinating question. I think I'd begin with the premise of the first thing we had to deal with in the aftermath of Katrina. And I'm not talking about a week, a year. I was actually at the Coast Guard working for Admiral Allen at the time, who was ultimately became the chief federal coordinating officer. But a few years after Katrina struck, which was people were still reeling, I was at the Department of Homeland Security as an associate general counsel for ops and enforcement, and I got an opportunity to go over to FEMA. And when I got there, I wasn't well received. They weren't happy about having a chief counsel or really any counsel at all. And the administrator had asked me to come, and I said, Craig, what do you want me to do here? And he said, you need to get the agency to use its lawyers, and you need to figure out how the lawyers are going to do that. And the first thing we did was a survey of all of the clients and all of the lawyers. And when we did that, I went personally to the clients and said, this is going to take you a couple minutes, but we really need you to do this, because otherwise we're going to keep getting the same thing we've got. And you're not happy. The lawyers aren't happy. We're going to try to do something here. And ultimately, what the clients came back with was, hey, lawyers, you're overrating your own effectiveness. And the reason we knew that is we asked the lawyers how they thought they were doing in certain areas. We asked the clients how they thought the lawyers were doing in certain areas. And then it became very clear where there was misalignment of values. And you use the term SALT. And so I'll cut to the chase on that. When we evaluated all of the survey results, what it came down to was the biggest gaps between the lawyers and the clients. Remember, FEMA is an emergency management agency. FEMA does two things. It writes checks and it has meetings. And generally, no one comes to the meeting unless FEMA's written a check. And so there's a whole, it's a grant-making organization. It's also an organization that coordinates when emergencies happen, but it lives in a time, it really does live in near constant crisis. And so the client said, we need lawyers who are solution-oriented. You're not giving us solutions. You may be giving us advice, but you're not giving us solutions that are oriented towards the problems we have. When you do give us solutions, we need to understand what you're talking about, because sometimes when you talk to us, we don't even understand what you're saying. And there's a footnote to that. And many of the clients felt the reason the lawyers didn't understand how the clients needed to hear the advice, or the clients didn't understand the lawyers, is because the lawyers didn't understand the mission. They just didn't understand the mission of the organization. They understood the mission of the law firm, just not the organization it served. And then, so that got us to solution-oriented, articulate. The clients all agreed that they needed legally sufficient advice. I did have to have a conversation with the largest group of clients, these federal coordinating officers, and I said to them on your jail comment, look around. Have any of you ever been to prison before, right? Do you know any other FCOs who've gone to jail? Your risk isn't going to jail. So let's stop talking about you going to jail. We're not going to let you go to jail. And if you go to jail, it's because you probably did something dumb on your personal time. That's not the risk you're facing here. Let's talk about the real risks we're facing together, and not some abstract concept of that. And I think that was important to get the clients oriented. Their risks weren't jail, and that sort of bravura wasn't getting us anywhere. And so last but not least, they said that they wanted advice that was solution-oriented, articulate, legally sufficient, and timely. And if you look at those four characteristics, what it comes down to is lawyers do operate in a world of other people's continuing crises. Lawyers are used to giving advice during other people's crises. But you as a legal advisor can find that you're in crisis even giving advice, hence the notion of advice in crisis, because you may not understand what the client's dealing with and how you can truly be helpful to the client. So I turned a couple points real quick to Lisa. Lisa did a absolutely brilliant definition of what a disaster is. And it was clearly very intuitive, but I'm going to cover some of the key parts, because I think in terms of teaching lawyers to be ready for a 21st century practice, it's important to understand that there's emergencies, there's disasters, there's catastrophes, there's literature on all of these things, but it really comes down to this. Emergencies are when you've got a need and you have enough to meet it. Think about a two-car accident in most communities. Plenty of police, plenty of fire, plenty of ambulances. Is it a disaster, perhaps a catastrophe for the person behind the wheel? Maybe, but not for the community. There's enough resources. A disaster is when you don't have the resources that you need to respond. And what do you do then? You go ask for help. You ask the state for help. You ask the president for help. You ask for help. And there's legal structures by which those asks come. And then there's legal obligations that flow from making those asks and accepting the help, right? After Katrina, we had a very different problem. And this is part of what we had to learn to train people on, because there's a third category of crisis, and it's called a catastrophe. And a catastrophe is when the very incident you're responding to is destroying the very capability and capacity you need to respond. Practicing law in each of those very distinct areas, an emergency, a disaster, and catastrophe, is different. And it's different in each area. And I would argue that I'm a big fan of the Brandeis quote from the prior panel, which is, you are a lawyer for the situation. You just have to understand what that means. It doesn't change your ethical obligations as a lawyer, but it does require you to take a broader view of ethics, because your clients are dealing with, how do I make decisions? What's the ethical foundation on which I make a decision? Who am I helping? Who am I not helping? Because in any situation where there's insufficient resources, somebody's not going to get what they need. And that's what the clients are constantly dealing with. And today, I'm a client. I'm not a lawyer in practice today, my lawyers understand that I'm trying to meet unmet need, and I'm trying to do that in an ethical fashion. And I get great support and advice because it's solution-oriented, articulate, legally sufficient, and timely.
Yeah, I love that. Having your Coast Guard experience must have contributed to that acronym, I'm thinking. But salty legal advice is something we should all, take to heart and think about. And, in our in traditional legal education, of course, one of the best things that we do is teach people very rigorous analytical thinking. Lawyers coming through a law school experience and then moving into private practice and public sector are prepared to take large amounts of data, find patterns, analyze from different angles. Then there becomes a critical juncture, and we've had a question from the audience that I was actually going to ask anyway. So thank you, audience member who contributed this. But there's a moment then when someone has to make a judgment, and in the situations in which each of you are functioning, especially during a crisis, the lawyer has to be someone who's making a judgment. They're just, David talks sometimes about the one-handed lawyer who, the client comes and they need the lawyer to make a judgment. And the lawyer says, well, on the one hand, and on the other hand, and you've got how many hands does the lawyer have? And they're not helping to make a judgment. How can we teach judgment? I'll ask each of you. Brad, start us off since you're warmed up on this topic right now.
Well, I think first of all is recognition that lawyer risk tolerance and client risk tolerance may not be the same, and in crisis, I'll almost guarantee you they won't be. The client, if they're an emergency manager or the person accountable for resolving the crisis, is likely to have a much higher degree of risk tolerance because the stakes are very great and the problem is large. And so they'll do things they wouldn't usually do in order to solve an asymmetric problem. I think lawyers have to understand that mindset shift and understand when their risk tolerance has to change as well. The other thing goes back to that salty legal advice, and it's if you're going to articulate that there are a range of options, it's fine to provide the range. And in fact, it's great to provide a range, but you at least need to say what your advice is, right? So if you have 4 options, you say, there are 4 options, I rank them this way. Client might turn to you and say, what would you do? And I'd say, I do number 1. Here's why I do number 1. And Scott, the only other thing I'd add to that is, I think it's critical to teach law students and clients frameworks, right? We can teach analytic skills, but at the end of the day, there's just a couple critical frameworks. One comes out of the Harvard School of Public Health, which is swarm leadership. We can talk about later. One comes out of the work that Eric Stern's done around tasks of crisis leadership, because as a lawyer, you can help make sure that clients who are harried proceed through those tasks. And then the other is ethical framework, and not just the legal ethics, but the ethics of making decisions about people.
Yeah, thank you. And I know you worked with Eric, in your project doing simulations, which I thought was a brilliant way to, you don't have to learn this right in the field every time. You can actually design, and people like Eric are brilliant at doing it, simulations that lawyers get into and can practice and see some of these skills. Lisa, to pick up on something you said, interestingly, you're training lawyers in PR. Something tells me this has to do with adopting a broader perspective and exercising judgment. Say more.
Yeah, I'll jump to that, but I want to just build on something that was just said. I am also a big proponent, and we are a big proponent of teeing up options. But it's not just options, it's options with a discussion of the trade-offs. And I think that is super helpful because it does drive a more pointed conversation about the different risk trade-offs, which I absolutely agree with Brad. A lot of times lawyers and clients will start in a very different place, but that seems to be a helpful way to drive forward that conversation. The other thing I might add to that is, teaching lawyers it's okay to ask for advice and talk both to other lawyers. I mean, for us, we have a large department. We encourage people to reach out if they're struggling with issues, but even amongst a team, right? So you don't have to necessarily come with the answer, though I absolutely agree with what Brad said. A lawyer should have an opinion and why. but you can put forth the options, the trade-offs, have a good dialogue, and then collectively decide. Like, I think that's super helpful because it also then brings up maybe other nuances, because when the lawyer was formulating the options, again, back to something Brad said, if we don't fully understand the business and the objectives, we may be off on our options. And then I'll shift to just your PR point. And yes, look, a narrative and understanding your stakeholders in the broadest sense, super, super, super important. And PR always has a seat at the table for us very directly. And we actually have a PR team within our corporate, external, and legal affairs department. I mean, it is they sit with us. But what it does, I think, do probably more than anything else, as I think about the multidisciplinary nature and the multitude of stakeholders you can have, they are very good at bringing the perspective of helping us think through all the stakeholders and who do we need to think about, what is, they're going to be their concern, how are we addressing that with the path that we're going forth with. Are we addressing it partially or not? If we aren't, what are their concerns and how do we best answer them? But it's, that's not a skill set I certainly ever sort of came into a legal department with, right? But, getting some basic training and just understanding how that works is very valuable. And then, in some of the book, I know people talked about lawyers also having to engage with the press sometimes, right? And so just even having those kinds of PR skills are also helpful.
Thank you. Really interesting themes there that to pick up on. One of the things that I talked about in my chapter was we're teaching about design thinking. I'm running a course on design thinking for lawyers, and there's a couple of techniques we're deliberately trying to build into that. One is the stakeholder analysis. When you're trying to solve a problem, it's lawyers, we typically, lawyer psychologists, that we're autonomous. We're going to go off on our own and solve the problem. I know what your problem is. We don't listen very well sometimes. And, we want to prove that we're the smartest person in the room, maybe because it's back to first year of law school when the performance pressure to prove you're the smartest person in the room really comes to the fore. That broader stakeholder analysis and stepping back and asking questions and empathizing and understanding the problem from many perspectives and different stakeholders has been really helpful to our students. A second thing we're doing on this, on the thought of, teeing up options. Traditional legal education, of course, when you throw up an idea, you're supposed to gun it down from every possible angle as quickly, as brutally as possible. Our business school students comment in joint courses where there's MBAs and law students together that how come the law students are so mean to us in class, which is kind of funny. But what we're trying to teach separately, in the design process, the way designers work is everybody heads down comes up with a set of ideas individually, and then each individual gets up and presents their ideas without critique and shooting down the ideas yet. The group sits back after everyone has talked about their ideas, and then they can start to group. Then they can apply that rigorous, analytical, critical thinking. It's a much better and different process, and it's not that difficult to do. The last thing you said that I think is brilliant is it's okay to ask for advice. I keep telling my students about this because, again, there's so much performance pressure, and there's this, idea that the lawyers got to on their own have the idea, and we don't teach lawyers enough to build networks to ask for advice. Munir, I think your example of how you succeeded brilliantly in the work you were doing in the immigration ban was that you had a network and you were out there asking people advice. Can you build upon that and what else you're doing in the clinic to foster, brainstorming, judgment, options, and network building?
Yeah, and I think this builds off of what Lisa was saying about the importance of teams, and to your point, Scott, about the kind of classical atomized approach to or experience of law school in the traditional classroom, which in many ways I think clinics are designed to try to counteract. They're a form of counter programming to that. And I've been doing clinical teaching for roughly 20 years, and I have over that time, one of the biggest developments in my own thinking and understanding actually has been to center on collaboration, not as some kind of soft skill that is nice to have, but as indispensable to doing complex lawyering. And part of that is because no one of us can be expert on everything that's involved, particularly if we are interested in taking interdisciplinary approaches to problems. But even within the sole discipline of law, no one of us is going to bring the entire knowledge base that's necessary for the kinds of complex problem solving that we're talking about. But the other piece of this is that I think is very hard to teach. Your basic question, how to teach judgment, is very hard to teach judgment to individuals in an atomized environment. Judgment is not a reflex, right? It's not like either your knee bounces in the right direction or it doesn't. It's a process built through discernment and reflection. And each person on a team will bring their own contributions to that. But once we move beyond the simpler problems, the routine, repetitious problems, which are essentially, require a kind of algorithmic thinking, and we move into a space where the algorithm fails, where we have to build from the ground up what the options are, how to weigh the competing considerations, and to discern, the differences in positionality that Brad was alluding to. Those are things I think that we shouldn't trust individuals to do competently on their own. And so the team then is, again, not kind of a nicety in lawyering, but absolutely indispensable to it. And so what that's led to in my thinking and the work that we've done in our clinic is we teach about collaboration more and more and more. It started off as a topic that we raised periodically. It moved into it being a one-off class that we would teach, to it now being something we're teaching pervasively. And one of the measures of success for our students is have they come out at the other end of the experience with not soft skills of collaboration, but hard skills of collaboration. Can they point to the things that they do that have made them better collaborators, that are producing better results? And one last thing I'll say about this, we talk about a little bit, Mike and I, in our chapter, going back to kind of what the learnings of crisis lawyering have been for us. So we describe crisis lawyering as a kind of stress test of the organization, in this case, our clinic. So how well are certain infrastructural aspects of our organization holding up? And one of the things that we discovered in the context of our work on the Muslim ban, which relates very much this topic of collaboration, is that when the immediate crisis passed, when we had some time to do the kind of postmortem that Lisa was talking about, the reflection about what worked and what didn't work, one of the things that became apparent is that the distribution of labor in the moment of crisis was skewed. And in fact, it tracked onto the kinds of inequalities that exist in society generally. Different there, and not to put too fine a point on it, but there were kinds of work that we would think of as being kind of the unglamorous aspects of lawyering that fell disproportionately on women and students of color. And so that was a stress test for us. How good were our systems for ensuring the equitable distribution of work and opportunity in our clinic? And that experience showed us that there was a lot of room for improvement. So we actually, in the aftermath of that, made that explicitly part of our teaching and explicitly something that we were trying to measure. How are we doing on this score? And that changed the way we taught about collaboration. That made for us one of our teaching goals for students, for them to acquire the tools of awareness for how work is being distributed, and to affirmatively self-audit the roles that everyone on the team was playing, rather than waiting for the faculty to kind of raise that as an issue. For them to kind of set up their own teams, one of the things that we've tried to teach is what the infrastructure is for equitable distribution of work and opportunity.
Fantastic. You'd be interested to know that in my design thinking seminar this semester, my students all have client teams. One of the teams has a client that is one of our clinics, and the challenge they're looking at is workload management and distribution. So I might put them in touch with you. Lisa, when I talk to, I do a lot of teaching with, law firms. It's the primary place where you source your talent, and there's often, challenging transitions moving from, the private practice of law at a law firm to in-house practice. Especially around this notion of working in teams. When I talk to law firms about, have you done the postmortem? Well, we can't bill that to anybody, and there's resistance internally to put in any kind of structure around that. What would be your take on how to better prepare lawyers for roles like yours, across the arc of their careers?
I think part of that is happening from what clients are asking for. And let me just give you an example from my perspective. If somebody gave me kind of the legal memo, and I will say I see them rarely now, but, earlier in my career, we used to get a lot of the, 20-page, let me give you the law memo. And we sit there and then I look at it and we're like, I have to make a decision. What is this thing telling me to do? It's giving me kind of all of that analysis, but no practical, what am I supposed to do? What is my path forward? I understand there's a lot of gray. I will say we will push back on our law firms, right? And we'll say that's not the kind of lawyering we need. We need people to kind of shift. And to the credit of the law firms, I will say people are doing that because there's also, billing pressures as well. We all have budget pressures. So I do think part of it is on us as consumers of the legal services to provide the guidance on what is the kind of legal work product we need. So I think that is a helpful feed into the process of some change on that. The other thing I will say is, we have our outside lawyers very much as well as part of our teams. And hopefully that also then gives them some insight into in-house lawyering, because I do agree with you. I think it's different. At least for me, it was very different coming from a law firm to in-house lawyering. And one of the biggest changes was I was supposed to have an opinion, right? I couldn't just say, here it is, you decide. But I think when we work hand in hand with them and we do bring them in as part of our team, that is a helpful thing as well. But I would also then encourage law firms to think about some of these different kinds of trainings. In some ways, if I think about law firms trying to design their practices and help their lawyers best serve their clients, if that's what clients are asking for, I do think there may be a growing sort of push within law firms to also think about how to provide that type of training.
Yeah, thank you so much. I'm going to invite Eric to join us and turn his camera back on for some reflections. And specifically, Eric, I know you and Brad worked really, really closely together on the FEMA project, brilliantly. A question I still was going to try to ask Brad is, how do you prepare leaders to work better with their lawyers? And you guys did a lot of that. So that's just a prompt. You don't have to take it, but I'd love you to wrap us up for the next 5 minutes or so.
So I'm not sure how far I'm going to get on that one, although it's definitely going to be implied in what I want to say. So it seems to me, if we think about the task of preparing lawyers to participate in crisis management in the environments that we're seeing now and that are likely to become more challenging in a number of ways moving forward, there really are two pieces that we've been hearing about. So one is the question of defining the lawyer's role or roles and having the lawyer perform excellently within their professional specialty in playing the role of the lawyer. That's actually more complex than it sounds. And in the first panel and in this panel, we heard about the role of lawyer as narrow technical expert, and we heard the role of lawyer as wise counselor and connector and conflict resolution specialist. And so that's a lot, just that. Then there's the second piece, which is preparing lawyers to work with other people, including leaders, and vice versa, preparing other people to work with lawyers. And I do have some thoughts about that. One of the best ways to do this is to practice in safe circumstances. And so the simulations that you alluded to before, role-playing exercises, give people a chance to practice their professional skills, even to inhabit other roles. And this is really critical. If you want a lawyer to work well with the public affairs folks, the communicators, as Lisa was suggesting, very good way to do that is to let the lawyers walk a mile in their shoes, and to give them an opportunity to answer a journalist's questions and see what the headlines might be, what story the lawyer would write, and show them the consequences of saying no comment when there is a situation where the brand of the company is at stake, where there's a perception that the company is not taking responsibility. And so that the lawyer really understands how difficult the job of the other professionals are. Maybe even more importantly, giving the lawyer a chance to inhabit the role of the decision maker who has to make these tough calls where perhaps rules or administrative constraints seem to be at odds with the humanitarian imperatives of helping people in dire distress. And so to have to give the lawyer a sense of why it is that, as Brad Kaiserman said, the leaders need solution-oriented advice that will advance the overall mission. And remembering the mission, and in the realm of where FEMA and the Red Cross work, this is about helping people who have had their lives and livelihoods disrupted by disaster. And so empathy for the other role players on the team, and empathy for the disaster survivors and others in that ecosystem, really, really vital. And in fact, one of the results of Brad's survey early on was that the lawyers lacked all of those kinds of empathy. And so we designed exercises for the lawyers to try to build empathy and give them that bigger picture and a better capacity to understand the others and what is at stake. I really like the point that a number have made about ethics, and this is particularly important when it comes to government lawyers. For government lawyers, they get a ton of ethics training. And most of that training is all about who you can accept a lunch from or what types of gifts you can get. And it's in a very narrow anti-corruption type of context. But the realm of crisis management, disaster management, emergency management, spaces that we are talking about here, there are big questions of right and wrong, questions of value, and how to weigh competing considerations against each other. This is the realm of the moral philosopher. That might seem abstract, but thinking explicitly about some of the yardsticks we use to determine right from wrong and to help those who have the responsibility to make choices to better see right from wrong and make the right choice. That, in fact, when we interviewed the FEMA leaders, the federal coordinating officers, senior leadership, we asked them what they wanted in these crisis situations. Many of them said, we want to do the right thing. Well, that's great, but the hard part is figuring out what the right thing is. And I think, thinking more systematically, seriously, deeply about ethics and preparing lawyers and those they work with to think about those bigger ethical questions is really important. And that is, I think, one of the ways that you teach judgment. And I will leave it right there.
Thank you, Eric. This interdisciplinary approach and bringing your expertise in crisis leadership to the legal profession is truly groundbreaking, and we're really grateful for the book, for you and Ray. I want to say thank you so much, Munir, Lisa, Brad. This has been the most fun I've had in the panel for a very long time, and I'm really grateful for all the great ideas you've given to us. I thank you. Our next up is we have a special conversation on crisis leadership and the Transformative General Counsel. How you can increasing roles in business, government, and society is the general theme. And David and Brett Hart, the president of United Airlines, have had this great conversation. Brett, as you can imagine, is really, really busy right now. We taped the conversation 30-minute long, and we're starting it this week. Brian, turning it back over to you to tee up the video. And thank you again, Munir, Lisa, and Brad. So great to have you with us.
So thank you all again for what has been a terrific day. I hope you will agree with me of outstanding conversation with a number of leaders around the issue of crisis lawyering and how do we prepare lawyers for it? How do lawyers work collaboratively with other professionals? But when we thought about bringing this theme all together, we wanted someone who both had an incredible breadth and depth of experience in the legal profession in thinking about these issues, but more generally in thinking about them from a broader perspective of thinking about what they mean for great companies around the world. And when we thought about this person, we thought there would be no person better than Brett Hart, who has moved from being the general counsel of United Airlines, as well as other companies beforehand, to now being the president of that great airline. And we were just absolutely thrilled when Brett said yes. And so Brett and I are going to have a conversation about the issues that we've been discussing today from the perspective of someone who really is seeing them in their broadest perspective. So Brett, thank you very much for being here.
Well, thank you. It's a real pleasure to be here, and couldn't think of a better place to spend my afternoon than talking about this with you and reflecting on what we've all seen and what we've lived through and what's ahead, quite frankly.
Well, thank you. I know how valuable your time is. So let's kind of start a little bit from about your journey into your current position and really into the airline industry, because you came from Sara Lee, where you were the general counsel there, following in the footsteps of someone that we both greatly admire, Rick Palmore. And that was a consumer product industry. This in some ways is a consumer industry, but of course a very different kind. So talk a little bit about your own journey into United Airlines and journey into your current role.
Sure. So I actually spent close to a decade at Sara Lee. And as you mentioned, I had the great pleasure of learning and growing under Rick Palmore. And it was a real pleasure, and a lot of, I'm sure, what we'll talk about today, I will simply be repeating what I learned at the knee of Rick Palmore. But I really loved Sara Lee. I did, and I enjoyed consumer products, and I'd only been general counsel of Sara Lee for about a year and a half at the time that the United job opportunity came along. I knew that from my perspective, if I was going to leave consumer products and leave Sara Lee, then I wanted to go to a totally different industry, and I wanted a really challenging industry, one with a great brand and with no end to the kinds of issues that we all live to be confronted with and have the opportunity to address. And I've certainly found that with United. I joined right after the merger of Continental Airlines and United Airlines. And I was the only member of the executive team who came from the outside.
That in and of itself must have been a fascinating time for United and for the industry, which had seen many important mergers. And you join as the general counsel of now a much larger corporation. And then actually, after not such a long period of time, you are then promoted again into a even more senior leadership position, eventually becoming, for a time, the CEO of United before your current role. And one of the things we're very interested, we've seen this trend kind of happening in lots of different areas where general counsels are being promoted into even more senior strategic leadership roles. I often tease my friend Brad Smith at Microsoft and say he's kind of patient number one for this, as he went from being the general counsel to the chief legal officer to the president and now the vice chair of Microsoft. But we see Ken Walker at Google, or Amy Weaver at Salesforce, or Horacio Gutierrez at Spotify. We see a number of people moving into this role. role. And I wonder why you think that is. That is, why do you see general counsels being promoted to these even more important kind of strategic leadership roles for the whole company?
Yeah, I see it as a natural progression. Like when you think about the roles that general counsels have, especially in highly regulated industries, or you see it in tech, you see it across different industries. It's really a deep enterprise-wide role, and there is both the opportunity with the exposure with the board and with the executive team to have a perspective and an opportunity to work across areas that really isn't presented by many other positions in the company. So when you have people, present company excluded, but when you have people like Brad and Kent and Amy and Horatio, and they have the opportunity to demonstrate their ability not only to address the legal issues, that's sort of the, that's the baseline, but to also weave into that an appreciation of the strategy of the company, the implications of outcomes, in a way that you don't see happening in other areas across the company. I think it's just indicative of the fact that you have really talented people moving into these roles who have the capability to do much more, but at the same time keep the legal function operating at a really high level and bring a perspective, quite frankly, that is unique to the company.
Well, I think present company is very much included in that description, and I know you're too modest to say that. But my sense is we're going to see more of this, particularly as companies increasingly face challenges that are different and unique than the kinds of ordinary business challenges that companies have faced in the past. And I like to think of kind of these in some sort of in terms of 3 S's, that companies are now increasingly facing issues around sustainability of every kind. They're facing issues around stakeholders and how they interact with stakeholders at all levels. And increasingly, particularly in the last 18 months, around issues of social justice. And all of those present new kinds of challenges for companies where both law is central to these issues, and yet they're about so much more than law. And I wonder kind of how you see that in your current position, where my sense is all 3 of these issues or kinds of issues are very much on your plate.
Yeah, without question, they're at the forefront, and they're all interconnected, as you mentioned, and very nuanced. So there are no simple answers to the relationships with the communities that our folks live in and raise their families and that where we do business and connect with our customers and consumers. And that's the same with the social issues. The issues that we're dealing with today have just as big an impact on our employees as they do the broader community, because we are, with 70,000 employees, we are a microcosm of the broader community. So our people are coming to work and they're bringing the same issues and that are sort of dominating the news as well. So there's, I think, gone are the days where we can conveniently, as corporations, turn to the side and pretend not to see or not to have to address or engage in these issues. You don't have the ability to do that anymore. And quite frankly, I think it's a good thing, because I think we have a responsibility to engage across each of those areas, whether it's sustainability or social justice, and in particular, to engage directly with our stakeholders and our stakeholders across a lot of different areas. I consider employees to be stakeholders, shareholders to be stakeholders, the mayors and community leaders in the cities where we operate are stakeholders. And all of these relationships, when you bring them together, are really complicated. But I also think to the larger point, it plays directly to the strength of of lawyers and the department and legal training and the way that we think about and we manage through the issues that are related to these various groups.
Well, that idea was certainly tested when you became the president. I think it was May 11th, 2020, in the midst of a global pandemic, several days after the murder of George Floyd, the airline industry facing its most challenging time ever, I think. And I wonder if you could talk to us a little bit about what those kind of first few weeks or months were like, and how you brought some of those skills to bear that you just talked about, coming from the general counsel position to this new position at, again, one of the most challenging times probably in the history of your industry.
Yeah. And to that point, I think there's no question it's the most difficult period that our industry has ever faced. And certainly at the time that I was promoted, and at the time that my current CEO moved into the CEO chair at the same time, we were working on dual tracks. We were still trying to figure out whether or not we would have to, significantly reduce the size of the company, or shut it down for some period of time. Or continue to push through. So we were dealing with all of those issues and the uncertainty that our frontline employees had with trying to understand the pandemic and its potential impact on all of them. And then George Floyd and the implications of what was happening in our streets and in our communities. And again, how that was even impacting our own employees who live in those communities. And I myself, living on the south side of Chicago, we were all seeing it, and I with 3 young boys. So again, it was just crisis with a capital C. But again, I think part of the way that we are trained and the experience that we bring to the table is that even under the most difficult circumstances, I think that we can see clearly that there are best case scenario outcomes. And I think that, what you bring from the general counsel table and from that experience is an appreciation for the fact that you have to identify a North Star in this process. And that North Star being the best possible outcome under these circumstances, not the ideal circumstances under any scenario, but the best possible outcome under this crisis. So, and I think that we're able to do that. And I think that my background allowed me to understand and appreciate the value of just engaging with people and being as transparent as possible and having open and clear discussions throughout the organization. And even talking to our organization about what it was like to be, the first Black president in the history of the industry while we were going through the pandemic, but at the same time dealing with the issues related to George Floyd. And I think my background gave me a comfort and a base to do that in a fairly unique way.
That's a really critically important point. And one of the things that we've been talking about in this conference, and one of the things that the terrific book on crisis lawyering that kind of frames our discussion here is both the advantage, but also the challenge that lawyers have sometimes in reaching these kinds of, let's call them, creative, adaptive solutions to new problems. That is, we're trained very well to kind of work within an established framework. And oftentimes, just to be very honest, to see all the risks and all the problems and all the difficulties and to counsel caution. And yet, in these sorts of circumstances, it requires a kind of an imaginative thinking, a reinvention, a rethinking of what the problem is and what the range of solutions are. And I know that you yourself have been able to do that, which is why you're sitting in your chair. But I wonder, how do you try to get your lawyers to think this way, and maybe to think a little bit about both the lawyers in United, your internal lawyers who you used to be directly sitting with every day, but now are seeing in a somewhat different way from your different role, but also the many, many outside law firms that United also has to have to be able to move forward in the way in which you're thinking about. How do you get people out of, if you understand my way of saying, that traditional lawyer mindset to try to reach these more creative solutions?
Yeah, in a lot of ways, this is sort of a perfect testing ground for that. Because we live with crisis, again, with a capital C, but a lowercase c all the time. And it's a perfect opportunity to get the point across that in most instances, no matter how significant the crisis may be, we have to be comfortable operating in gray space. And in operating in that gray space, you have the opportunity to think about things in different ways, and to not only appreciate the simple answer that's directly in front of us, that is driven by your perspective on the law and that piece of the law that you control within the organization, but then thinking about the implications of that outcome and how the business operates in the weeks and months to come, and what does it do with respect to our reputation, our ability to operate. So we have a perfect environment for both good and for bad to continuously talk about that with the lawyers here. And it's something that I did all the time, and quite frankly, it's something that Rick did with me very early on. When I'd run into his office with the answer, the lowest hanging fruit, and it was, it was safe and it was good. And he said, okay, I got it. And that one eyebrow would go up, and he'd say, but what are the implications of that outcome? 3, 4, 6 weeks from now, have you tried to look around the corner and understand, appreciate, and how far out into the organization have you tried to reach in order to understand the implications on the business? I think we tend as lawyers to work within our own knotholes or our silos. And we're very pleased with the outcomes that we come up with because it's X, Y, and Z. But the answer is often the one that is not obvious at all. But the only way that you get there is by appreciating the broader implications of the outcome and, frankly, the broader objectives of the organization.
And to do that requires lawyers to do something else that's oftentimes not just difficult for them constitutionally, if you will, but also organizationally in terms of their position inside the organization. And that is to engage in interdisciplinary collaboration around problems that are not just about law and legal regulations, but also are fundamentally, let's say, about what's possible technologically, or about customer relations, or about public messaging. And I wonder, from your perspective, how are you trying to get lawyers to move outside of that silo? Because the legal department often is siloed in the way in which it's organized. The lawyers sit together. They're oftentimes separated from the business. Their training is different. So I wonder how, in this kind of, as you say, crisis with a capital C, are there things that you've done to try to facilitate that kind of interdisciplinary teamwork or collaboration?
Yeah, here our lawyers are pretty much embedded with their business people. And the point that I would make is that I do believe it's possible to do that and still maintain the appropriate independence that lawyers should have. And that is, that's an important consideration. But I think in order to be successful within the organization, you have to be there right at the opening of the funnel. You have to be part of the strategic discussions. You have to, again, understand where your business people are trying to go. And they have to respect you as not only just as a lawyer, but also as someone who can add to the overall value of the strategic process. And I think it's hard to make that happen unless you as a lawyer understand and appreciate that adding value with your business partners means understanding your business, and it means understanding those partners and what their objectives are, and simply sitting behind the desk and applying, what you've learned about your area of specialization only gets you so far. That's sort of the table stakes. Coming in and being a very good lawyer, knowing how to analyze the law. That's what gets you in the door at United, and I'm sure at a number of other places. In order to be exceptional at what you do, in order to set yourself up, I would suggest for even broader opportunities within organizations, you have to demonstrate that, for lack of a better term, that emotional intelligence and ability to connect with the business and understand it, and still apply that independent legal thinking and to draw the lines where you have to draw them. But to be able to think creatively and bring a different perspective from the very outset. And that's where I think in a lot of instances, that's where the value lies, and that's where the opportunity to expand beyond just being the lawyer in the office, and that being exactly where they want you to stay.
So, Brett, there are a number of lawyers from terrific outside law firms on this virtual webinar. And what advice would you give to them? And again, you have a unique perspective of both. Well, you once were an outstanding outside counsel earlier in your career, and then you've been working in-house, including as the general counsel. But now you see things again from a somewhat different perspective. And I wonder, both, maybe if you could tell us a little bit about what you've seen that hasn't been successful for outside law firms, particularly when a company is undergoing such a serious moment as it is in this current pandemic. And then some things maybe you think that you've seen that outside law firms have done well that other lawyers could learn from.
Yeah, absolutely. And let me start by saying, I mean, with all the crises that I've been through in my professional career, whether it's proxy fights or catastrophic health issues with sitting CEOs or the pandemic and other very notable PR issues that we've dealt with along the way, critical element in every single instance has been the counsel that we receive from outside law firms, and in particular, the lawyers who are specifically supporting us. They have been partners for us in every sense of the word, and where they truly add value, again, they have an understanding of our business. They know the law cold. They're true experts in their areas, but they have an ability to apply that in a flexible way around the issues that we're addressing, and to move at the same pace that we move at, and to understand that there are broader considerations at play. Again, sometimes it would be very easy to say fight. And sometimes it's much harder to say, we get it, we could win this at the end of the day, but we could win the battle and lose the war. So there are other options, and this is what they are. Let's talk through them. So I can't think of a single meaningful crisis that I've gone through where the support of truly great outside counsel hasn't made that outcome, again, the best potential outcome possible. Where it hasn't worked, it has been counsel and support that just has a tunnel vision, and it is that counseling and advice that is geared towards getting to an outcome because it's a legally acceptable outcome, and then they're allowed to move on. to the next case and to the other company that they're supporting. And without feeling from my vantage point that they understand and really get the stakes and get our desire to get to an outcome that down the road is not going to tie our hands or do more damage than good. Because something can look great on Tuesday, and when you finally start living through it, the following Monday, Tuesday, Wednesday, the true implications start to come to bear, and it's not a great. It turns out not to be a great outcome. So I think the ability to think outside the box, but at the same time walk at the same pace with us, that's critically important.
And Brent, implicit in what you are saying is, you're very nice and you wouldn't quite put it this way, but it's a little bit of an indictment of what I do and the way in which we train lawyers. And I'd like to end this conversation on where our future is, because I hope we are at the tail end of our current crisis, but I don't think either of us think this is the last crisis we're going to see, and we may not even be able to anticipate where the next one comes from. That's a little bit of what the world is today and what incredible leaders like you have to stay agile about. But in order to do so, you need lawyers who are trained to think perhaps in a different way than you and I were trained at the very excellent law schools that we both attended, or the way in which I've been training my students now for many years. And so I wonder, as you kind of look out into the future to the new issues that you think lawyers are going to have to help you deal with, both as outside counsel, as inside counsel in your company, and as leaders like you at the highest levels of strategy in a great company, how should we be training lawyers for these new roles?
Yeah, again, first of all, I wouldn't presume to guess how you're training them and teaching them now. It's been 30 years for me, and I'm sure that it's spectacular, because I am really impressed with the folks that I see coming out of law school now. But what I will say is that there has to be an appreciation for, again, the fact that nothing, once you leave law school, is black and white. It just isn't. You have to take as a baseline what you get from the law and from the books, and then beyond that, you have to be, again, really comfortable in gray space. You have to be willing, at times, I will dare say, take some risk, and you have to be willing to put in the time to understand not only the potential outcomes that you're driving towards, and the work that you do has an impact on the organizations that you're supporting. You have to not only understand the potential outcomes, but you have to understand and be willing to embrace the implications of the advice that you provide. And I think sometimes we as lawyers get very comfortable with the idea of getting to finality. And what we do and the advice that we provide and the outcome that is reached, that's kind of like day one. Then it, in a lot of instances, it continues to play out, and the implications are not always abundantly clear from day one. So have some appreciation for the fact that doing your job purely from the legal perspective is sort of, for you, the baseline. And you have to be exceptional at that. If you're going to be great, like some of the people that we talked about previously, Brad and Kent and Amy, Horatio, and Rick Palmore, then you have to be able to look around corners and understand more broadly and more deeply what it is your clients and those who you're supporting are actually trying to accomplish.
Well, Brent, United Airlines is very lucky that, as Lyndon Johnson once said about my old boss, Thurgood Marshall, that they found the right man at the right time for the right job. I can't imagine a more thoughtful view of kind of from the leadership perspective about what it means to be a great lawyer and a great problem solver who collaborates with others, particularly in challenging times. And I'm certainly going to take the advice that you just gave me back to my students in my class when I go to teach them tomorrow. And I know that everybody who has been lucky enough to have watched this conversation will be able to take important things back with them to their own organizations to try to help all of us really be in a better position to help us through these challenging circumstances, which, as you said, are not going away, are only going to get more challenging as we move forward. I can't thank you enough for taking time out of your extremely busy schedule to do so. I hope this will be the beginning of a long-standing conversation in which we could get the benefit of your wisdom. But for now, I'll let you go back to that challenging job, and we'll go back to having some concluding thoughts about this very important day. Thank you very much, Brett.
Thank you. It was a pleasure.
Well, thanks again to Bret Harte. As I think all of you could see why he is such an exceptional leader. And he's also the embodiment of, as I indicated a little bit in our conversation, a broader trend which I think really highlights the importance of what we've been talking about today. That is, lawyers who are now moving into even more senior strategic policy roles in organizations. And this is not just true in the private sector, it's also true in the nonprofit sector. Michelle Warman is now moved up from being the general counsel of the Mellon Foundation to a more senior strategic role. We're seeing this increasingly in government. As Tom just illustrated, moving from a legal role into a senior policy role, or Jay Johnson and many others. And they're doing so precisely because of the importance of law in these broader settings, but also because hopefully we are finding more and more lawyers who have that kind of broad vision that Brett talked about, who could see around corners, who could see the gray areas. At the Center on the Legal Profession, we've launched a research project studying this phenomenon, and we hope to be able to report it back to you, both in written form, but also in a webinar of this kind, which we hope you will attend. But for now, I want to end our amazing discussion today by welcoming Ray and Eric back to the stage and thanking them for everything they've done to really facilitate this incredible discussion, to jumpstart it, and to offer a few concluding remarks. So, Ray, do you mind going first?
I don't mind at all. And I am quite overwhelmed with gratitude to the center, to you, David, and Dana, and Brian, and all of our panelists today. It was truly extraordinary to continue the conversation from the book, which is really what Eric and I think, I will speak only for myself, but it was these sorts of conversations that we hoped we would spark when we started to try to bring people together to think about these issues. I think that I will, close just with one brief comment. It is also important to think about we talk about the health and safety and well-being of our clients, of the communities in which we find our clients, but also to remember about the health and well-being of the lawyer, of the advocate, and that this work is quite hard and taxing, and that it is it is okay to take a step back and to take breaks and to try to sustain the work and to understand that this kind of work feels like a sprint sometimes, but it is often really a marathon, and it can be a career-long marathon, and that it is important to remember to pace oneself and to realize that crisis lawyers are humans too, and that they have to ensure that they're not always throwing themselves at these challenges when it might put their own health and mental well-being at risk, because this work can be really hard and really challenging, and then it's important to remember that.
That is just so important, especially as we have all lived through, Ray, such challenging times. Eric, do you mind offering a few words?
First of all, I'd like to just say ditto to what Ray said on both counts, both in terms of our thanks to all of the organizers, and for that matter, the contributors to the volume, and the reviewers and others that were a part of the wider project. Very much agree about this notion of an ethic of care, which extends to the lawyer as him or herself as well. So terrific. A couple of areas, just thoughts that I'll throw out there. Areas, some of which were explored in some detail today, some of which were touched upon, that I think might be helpful in thinking about where this field of research and education and practice might go. One is that I would like to call your attention to Scott Westfall's chapter in the volume, which really embeds crisis lawyering in a broader framework of legal problem solving, which I think is very helpful, and that gets at things like team skills and creativity, and draws on design thinking. And I do think that these approaches are teachable and conducive to creating better crisis lawyers. So excellent. Creating a learning culture for lawyers and having lawyers contribute to a learning culture in organizations, very important. I thought Lisa Tanzi's discussion of the practice in her shop of doing these postmortem debriefings, it's something that is very hard. And if you create a learning culture in an organization, you not only adapt better to the future, but you stop making the same mistakes more than once, and you weed out a lot of inefficiencies and sources of suboptimal outcomes. But it does require creating an environment where people feel free to speak truth to power and to criticize themselves and others in a constructive way. So it's hard. And that in turn can be embedded in a broader framework of knowledge management that has to do with the way that experience is processed, documented, communicated, made accessible quickly and efficiently when it's needed. We could have a whole other conversation with Brad Kaiserman about some of the other things he did at FEMA in terms of preserving opinions, and he created a disaster operations legal reference volume to support lawyers so they weren't all starting from scratch every time things were happening. There's more that could be done there. When you look at experience and when you try to learn from what has happened, you necessarily get into an evaluation question. And that came up in some very interesting ways today. Bea Lindstrom's discussion of the Haiti case, which she described as a legally losing strategy, but one that was embedded in a broader, more political understanding of the concept of the environment and context, is very instructive. And so, as you go in and look at that, do you look at narrowly at the legal part that didn't work, or do you do a much broader, big picture discussion of what those outcomes really were and what worked and what didn't. And you start to see that there's nuance hiding here. It's harder than it sounds, and there are some good practices and methodologies from other realms, I think, that could be applied. And by the way, that's a case that I think intuitively speaks to a sense of justice, that the legal mechanisms to create a just outcome were not available, but there was some restitution for folks who were harmed anyway. That's great. I think the 2020 election and some of the lawyers that attacked the 2020 election on spurious legal grounds. I mean, they amassed an enormous number of record number probably of failures in terms of all of the legal actions. Unbelievable. And yet, from a political perspective, from a fundraising perspective, from the perspective of pushing a narrative that has been conducive to Donald Trump's future political prospects and goals, makes me uncomfortable, but a fair amount of success. What's often been described as a big lie was successfully propagated, and the legal machinations here have lent, for some, a degree of weight to that. I find that outcome, for a bunch of reasons, rather troubling. But it also speaks to the complexity of thinking about what is success, what is failure, when it comes to these situations. And there's much more nuance here too, in terms of the relationship between processes and quality of work and the outcomes that are produced. But no time to get into that. There's some lines of research, partly linked to the above, or to the things I've just mentioned. But there are some things that could be nice next steps. In our book, we collected a bunch of war stories. Everybody told their stories in somewhat different ways and processed them in different ways. And Scott and I tried to create an overarching framework and to synthesize and to try to bring these diverse products together in something that allowed us to take stock of where we landed after the volume. I do think a more systematic way, kind of moving from war stories to systematic, methodologically informed case studies, could be valuable. Focusing on narrower domains and looking at approaches or strategies or ways of approaching the work that worked or didn't, and trying to figure out when to use which tools in the toolbox and enable better benchmarking. I think would help to take this to the next level. And then finally, I think when it comes to crisis lawyering and perhaps even informing the practice of law in other contexts, there are good practices from other domains in terms of using tabletop exercises, simulations. Here at Albany, we have a Center for Advanced Red Teaming that's doing some amazing things about inhabiting the mindset of the competitor or the adversary. Could be great for trial preparation, and for other contexts, crisis negotiations as well. That perhaps could be explored and might be part of the next generation of work in the area. I'll stop there. I'm just so excited, and there's so many different pathways that this community could explore together. And I will again thank the Center for the Legal Profession for fantastic work in putting this together. Thank you.
Well, thank you, Eric, and thank you, Ray, for getting us started on what was an amazing conversation. But as you say, just the beginning. At the center, we're now trying to do some of the kinds of systematic research that Eric suggested. So we have a project that we're actually putting in the field right now with actually EY Law, in which we are looking at how the legal function is responding to those three S's I talked about with Brett: sustainability, stakeholders, and social justice. We hope to have a major report out, as well as a major webinar shortly after the first of the year. And then we have a long-standing project on, I think, what is the hardest question, which Eric raised, which is, how do we measure the quality of a legal outcome? or an outcome in general? And how do we stop it from being narrow and siloed? And how do we stop it from being just about the inputs and more about the outputs and how they are related to the true stakeholders? And we've been working on that for some time. If you're interested in following this work, please do subscribe to our digital magazine, The Practice, where we have reported on this great project, but also many more. And we'd love to have you in conversation with us. But unfortunately, our time for conversation has run out. We are very, very rigorous about starting on time and ending on time. So I only really have time for one more thing, and that is to thank both Eric and Ray, all of the amazing participants who were here with us today as speakers and panelists. But most of all, I want to give a special thanks to the team at the Center on the Legal Profession, one of whom you've already met, Dana Walters, who really worked tirelessly to make this program, as well as the issue of the practice, come to fruition. But I want to give my most special thanks to someone who refuses to be shown on camera, and that's my incredible executive and research director at the center, Brian Fong, who is also the senior editor of The Practice and really did more than anyone to make this the success that it was. Thank you all for spending your time with us, and we look forward to continuing the conversation again very soon, because these issues there are no more important issues than these. Thank you all very much, and good afternoon, good evening, good night, or wherever it is you are. Thank you.
Thanks, everybody.